Good morning, everyone, and welcome to the Boston University Public Interest Law Journal Symposium entitled Human Trafficking, Then and Now, New Directions and Approaches to Exploitation. My name is Kennedy Barber-Fraser, and I'm proud to represent PILJ today as the editor-in-chief. Before we begin the symposium, I think it's important to explain how we got here. Almost a year ago, after becoming the editor-in-chief for volume 31, I reached out to my fellow staff editors to see if one of them would be willing to serve as symposium editor. PILJ had not hosted a symposium by itself in at least 2 years, and I felt it was time that we used our voice to contribute to a timely public interest issue and have a hand in igniting conversations on topics that we deem important and relevant. Madison Bush responded to this call, happily agreeing to take on the symposium editor role, a role we had never seen in action and of which we had little precedent to follow. From the start of her tenure to now, Madison has produced excellent work, which I am happy that everyone will finally get to see today. Starting from the ground up, together we devised a symposium with significant help from PILJ's faculty advisor, Julie Dahlstrom, and we won BU Law's 2021-2022 symposium competition. And not only did Madison step into the role of symposium editor, but she took on the role of managing editor as well, so that PILJ could, for the first time since 2001, produce a full additional issue centering the symposium. PILJ has chosen to put on a symposium today about a timely issue, human trafficking, which affects millions of people worldwide. It was important that PILJ, a journal that seeks to publish articles on current developments in the law and important topics, contribute meaningfully to this conversation. For me personally, it was important that I, as a former student attorney for the Immigrants' Rights and Human Trafficking program at BU Law, continue that same work in some way, because the job doesn't stop when you win asylum for one family, but continues with advocacy for the many others affected. It was a priority in general this year, but especially in this special issue and at the symposium, that we invite and incorporate a diverse array of authors and panelists. If you know even a small bit about journals, then you know that normally and unfortunately, women who look like me aren't serving as editor-in-chief of law journals, and those same law journals aren't necessarily publishing or centering women of color authors, survivors, those who have been incarcerated, and others with relevant experience. This is true even on issues that disproportionately impact those same people, such as human trafficking. But I am proud that in today's various events, you will hear from a survivor, women, a doctor, women of color, activists, professors, partners, and our very own US attorney, all of whom are experts in this field and who have something important to lend to this conversation. We as soon-to-be lawyers committing to fighting for justice were determined to incorporate and center a variety of voices so that we could have a purposeful conversation that works to move the needle on this issue. Law journals have the power to drive the conversation on important legal issues, and a goal of PILJ's executive board this year was to bring these public interest issues out of the pages of our volume and into conversation. We acted on this in the fall by hosting a panel on the death penalty to recognize our leading article under issue 1. And I am proud that PILJ has again taken this opportunity to do so. And I hope that today's symposium and our symposium issue, forthcoming in March 2022, invite you all to consider how we can better approach human trafficking and exploitation. I'm endlessly grateful for all of the speakers who accepted our invitation and have taken the time out of their day to be part of today's event. And I am also thankful to Julie Dahlstrom for all of her help and guidance in putting the symposium together. Thank you to our sponsors for supporting us in this endeavor and in advertising our symposium. Lastly, I'm grateful to Madison Bush, PILJ's symposium editor, for trusting in my seemingly risky request and daring to take on a role with incredibly fruitful results. I hope that today's symposium redirects everyone's attention to the pressing need to end human trafficking. Thank you for joining us today. Next, I'm going to be introducing Onwuachi-Willig, who is here to give our opening address. Angela Onwuachi-Willig is Dean of Boston University School of Law and the inaugural Ryan Roth Gallo and Ernest J. Gallo Professor of Law, the nation's first endowed professorship in critical race theory. Prior to joining BU Law in 2018, she served as Chancellor's Professor of Law at the University of California, Berkeley. Dean Onwuachi-Willig is a renowned legal scholar and expert in racial and gender inequality, as well as anti-discrimination law. She writes in a variety of areas, including employment discrimination, family law, and critical race theory. She is author of According to Our Hearts, Rhinelander versus Rhinelander, and the Law of the Multiracial Family from Yale University Press. And her articles have appeared in leading law journals such as the Yale Law Journal, California Law Review, Michigan Law Review, Georgetown Law Journal, Northwestern University Law Review, and Vanderbilt Law Review, to name a few. Earlier in her career, Onwuachi-Willig clerked the United States District Court of the Northern District of Ohio and the United States Sixth Circuit Court. She practiced law as a labor and employment associate at Jones Day and Foley Hoag. In 2011, she was a finalist for the Supreme Court of Iowa. She holds a bachelor's degree from Grinnell College, where she now serves on the Board of Trustees, a JD from the University of Michigan, and a PhD in Sociology and African American Studies from Yale University. In 2001, Onwuachi-Willig was elected to the American Academy of Arts and Sciences. Please join me in welcoming our dean.
Morning, and thank you very much, Kennedy, for your able leadership of the Public Interest Law Journal this year. What a wonderful run you've had. And thank you for all the fantastic work that Symposium editor Madison Bush and you and others have dedicated to organizing today's event. Human trafficking is a global problem that requires a global solution. And unfortunately, in recent years, the United States has not wielded its influence on the global stage to prioritize the human trafficking crisis on an international scale. In fact, the previous presidential administration, despite expressing concerns about the epidemic of trafficking, pursued policies that undermined systems of protection, which made trafficking survivors much more vulnerable to exploitation. Students in our Immigrants' Rights Human Trafficking Clinical Program have seen the impacts of the prior administration's policies firsthand. One survivor, we will call her Jamie, was a survivor of sex trafficking who stepped forward to apply for protection many years after the victimization had already occurred. But after more than 2 years, the immigration agency denied her application, applying ultravirus filing deadline to her case. With the help of students in our clinic, Jamie waged a long-fought battle to successfully appeal her case. Reading the decision, Jamie was overcome with happiness, believing that the legal system, after many years, had finally believed her account of what happened. She was granted a T visa, a specialized form of immigration relief for trafficking survivors. But she still wonders why it took years for a system that was established to protect her, to provide recognition and a remedy. And there are so many like her who do not have access to a lawyer or who are too afraid of deportation to step forward. Trafficking is also harmful to US citizens. Last spring, WGBH News, a local PBS affiliate, produced a documentary series called Unseen, The Boy Victims of the Sex Trade. And according to their reporting, from 2018 to 2021, more than 400 boys in Massachusetts, many of them US citizens, were referred to the Department of Children and Families due to concerns of commercial sexual exploitation. And that reflects just 15% of the total number of referrals made about possible sex trafficking. Now think about that. That means in just 3 years, the Department of Children and Families received reports of more than 2,500 Massachusetts children suspected to be victims of sex trafficking. And we can only imagine how many cases went unreported. Unfortunately, during the previous presidential administration, actions taken to protect victims from sexual trafficking greatly diminished. In 2018, the Justice Department opened only 657 investigations into sex trafficking, as compared to 1,800 in 2016. And we are highly skeptical that incidents of sex trafficking had decreased by nearly 2/3 in those 2 years. Furthermore, federal prosecutions for federal sex trafficking fell precipitously, and policies were implemented, making it more difficult for sex trafficking victims to clear their records. As victims advocates, we must repair the damage that has been done over the past several years and restore the safety and humanity of all survivors of human trafficking. The Biden administration has made strides in the right direction. In December, President Biden released the National Action Plan to combat trafficking, but we still don't know if it will result in meaningful changes on the ground for survivors. Some experts suggest that advocates for human trafficking, survivors of human trafficking, may look to other social movements for potential solutions. In a 2020 article entitled "The Anti-Trafficking Cause, Front Exceptionalism to Shared Struggle," Sienna Baskin, an attorney and a former director of the Anti-Trafficking Fund at NEO Philanthropy, and Huey Hewitt, a doctoral student at Harvard University, underscore these points. They declare, quote, "We need to bring the cause into comprehensive movements for racial justice, gender equity, and migrants' and workers' rights. Solutions to human trafficking are to be found within the goals of these movements. When all people have the right to migrate and work safely, and when people of all genders and races have the same rights and opportunities, human trafficking will cease to be a systemic problem," end quote. Baskin and Hewitt recognize that Black Lives Matter and other movements have spotlighted the harms faced by BIPOC and LGBTQ+ individuals at the hands of the state. And they have demonstrated how often responses to gender-based violence, including trafficking, focus disproportionately on prosecutorial and criminal law tools, which often negatively impact communities of color. This is why today's symposium is so important. It is an opportunity to gather together as a community, spark conversations, and envision new solutions. It is a chance to re-energize one another and to recommit to the cause. At Boston University School of Law, we are more committed than ever. Our students and faculty have partnered with Attorney General Maura Healey and others to build tools that enable frontline responders to identify labor trafficking survivors and to ensure that they receive trauma-informed comprehensive services. Our Immigrants' Rights and Human Trafficking Program has worked with many of you to pass state statutes to promote post-conviction relief for trafficking survivors in Massachusetts, and to require that all state and local officials have a policy in place regarding immigrant survivors of crime and UT visa certification. Moreover, U.S. Attorney Rachael Rollins, who will deliver today's keynote address, has worked tirelessly to dedicate resources to multidisciplinary teams to address trafficking and to promote a survivor-centered approach. But despite all of these efforts and the other important work in which all of us are engaged, more is needed, and that is why today's event is so important. On behalf of everyone at BU Law, I want to extend my sincere appreciation to the co-sponsors of today's symposium, BU Spark, BU's Initiative on Forced Migration and Human Trafficking, the Human Trafficking Institute, Wilmer Hale, and the Massachusetts Office of the Attorney General. I'd like to take this opportunity to recognize the leadership of Attorney General Maura Healey, who has truly made human trafficking a priority in her office, dedicating resources not only to cases of human trafficking, but also to broader policy-related issues. Moreover, the Attorney General's office has led the Commonwealth Anti-Trafficking Task Force, of which BU Law is a part, to consider and develop more nuanced approaches to this important issue. Attorney General Healey cannot be with us today, but she has graciously prepared a brief video greeting for all of our attendees, and I'm delighted to introduce Attorney General Healey. Thank you so much again for joining us today.
Hi, everyone. I'm Maura Healey, your Attorney General in Massachusetts. I'm so glad to be able to take part in today's conference. Thank you to BU Law, today's co-sponsors, and all of the amazing speakers and presenters who helped make this event such a success. I'd also like to recognize my office's human trafficking team, led by Beth Keeley, who will also be speaking today, as well as the survivors and community leaders who are taking part in this important conversation. This is an opportunity to discuss the emerging challenges around legal protections for victims of forced labor and sex trafficking. Your participation today is critical because we need lawyers who are there to represent survivors and be a voice for victims. We need law students who are determined and dedicated in their education to join us here in this work. We need help from law enforcement and victim service providers, serving as our eyes and ears in the field. And we need survivors and community activists to continue sharing their stories, to raise their voices so that we can better create and uphold laws and policies that protect our most vulnerable. You see, we're in this together. This past summer, I met with a group from My Life, My Choice. These young women explained to my team how policy needed to change and how young people shouldn't have to experience what they went through. A little while back, I had an opportunity to meet with survivors at Lyft, their new harbor location in Worcester. They told me how Lyft had improved their situations and empowered them in their advocacy. But they also talked about continuing needs, like addressing the opioid epidemic, increasing access to affordable, low-threshold housing, increasing legal representation. Listening to their stories, I was reminded again of the strength and perseverance of survivors and of the responsibility we have to listen and to understand what they need in order to take real action. I assured them that my office is here for them, and we remain committed to the work to improve protections for survivors, to prosecute perpetrators, and to prevent human trafficking once and for all. I look forward to the work we can do together. Thank you for participating in this conference, and thank you for the important work that you are doing and will continue to do.
Hi, everyone. Thank you again for joining PILJ for this symposium. We will take a quick break and return at 10:25 for the first panel addressing federal versus state efforts to combat human trafficking. Thank you.
Good morning, everyone. So I'm just going to get us started once again. First, I want to introduce myself. My name is Karen Pitalor, and I am the Associate Dean for Experiential Education here at Boston University School of Law, and I am thrilled to be here today and to be able to moderate this wonderful panel. So I also did want to let you know that after the speakers speak, you will have an opportunity to ask some questions. So please feel free to right now in the Q&A portion, begin asking your questions, and I will ask them at the end. And this is panel number 1 on federal versus state efforts to combat human trafficking. So I'll begin with Dina Haynes. Professor Haynes currently serves as the director of the law school's Immigration Law Certificate Program at New England Law. Before teaching, she was an international human rights lawyer, serving as Director General of the Human Rights Department for the Organization of Security and Cooperation in Europe in Bosnia-Herzegovina, as Human Rights Advisor to the OSCE in Serbia and Montenegro, and as a protection officer with the UN High Commissioner for Refugees. She also received appointments as a human rights field investigator with the Office of the High Commissioner for Human Rights in Rwanda and with UNHCR in Afghanistan. Professor Haynes has provided direct legal representation to hundreds of asylum seekers and victims of human trafficking. Professor Haynes. You are on mute. There you go. We cannot hear you, or I cannot hear you. So maybe the best thing for me to do while Professor Haynes figures out the technology, and Professor Haynes, maybe you can talk to our wonderful Madison Bush and she can help you figure it out, or possibly you may be able to call in. So maybe the best thing is to go on to the next speaker. So I will let Professor Haynes go for right now, and I will introduce you to Tim Moran. Tim Moran has been Assistant United States Attorney since 2004, first in the Commonwealth of Northern Mariana Islands, and since 2007 in Massachusetts. He is Chief of U.S. Attorney Rachael Rollins' Organized Crime and Gang Unit, and Director of her Civil Rights Enforcement Team. which is an interdisciplinary group of attorneys, victim witness specialists, and a law enforcement coordinator who prosecute federal criminal civil rights offenses, including human trafficking and conduct training and outreach. Prior to becoming an AUSA, he was Assistant Attorney General in Massachusetts and was in private practice. Mr. Moran.
Good morning. Great. Thank you so much for having me. It's an honor to be here addressing this group. And I'll get right to it because I think there's a lot of great content this morning. So this panel was addressing sort of trends in federal and state efforts to combat human trafficking. And so I thought I would start there. One thing that's significant to start right with something important is that I've been at AUSA for over 15 years, first in Micronesia and for a long time here in Boston. I've been working human trafficking cases that whole time. It's been a priority of the last 3 or 4 administrations. I think what we're seeing in the Biden administration is a renewed priority, but also an attempt to really be more practical and get down to brass tacks. And so one of the things that we've done is that the White House, as the Dean just mentioned, released a strategy in December to combat human trafficking. And the Department of Justice released its own strategy to combat human trafficking in response to the White House plan about 3 weeks ago. It's a document worth looking at because it, for me, it's interesting that it really has a lot of both high ideals and goals and a lot of concrete items that they want to do. And I'm happy to say that in conjunction with a lot of the people who are on this call today, Massachusetts is actually already doing many or most of the things that they want us to be doing. So it's worth taking a look at. DOJ's national strategy embraces what they call the 3 Ps: protection of victims, prosecution of human trafficking, and prevention of human trafficking. And I think it's noteworthy that the Department of Justice, which is historically primarily a prosecutor's office, is embracing a more holistic approach to human trafficking. It's embracing efforts of other stakeholders, like the various people on this symposium today. And I think the department would join the dean in recognizing that we are not going to prosecute our way out of this problem. It's going to require the thinking of people in various fields doing various different things to really solve this problem. But as a prosecutor, a career prosecutor, I want to focus on the second P. That's what I know, and that's what I think I'm able to speak to you about. One thing that to remember is that everyone can and should do something to help with protection and prevention, but only our local, state, and federal prosecutors' offices can do the second P, the prosecution. Before I talk more about that, I want to take one small issue with the program. It's captioned as federal versus state efforts to combat human trafficking. And I'm going to make a mountain out of a molehill. But as lawyers, that's what we do. I don't like the idea of a versus there because in this area, I am really struck by the level of collaboration that we see among local, state, and federal law enforcement agencies and prosecutors' offices. I've worked in other areas of prosecution. I've done organized crime and gang work and other things like that. You don't see this level of collaboration in other areas of law enforcement. I think that's mission driven. I think it's because the people who work in this area want to be doing this and recognize that only by working together will we solve this problem. So I'm first going to talk about what I think local, state, and federal prosecutors all have in common in terms of approach and goals. And then I'm going to touch later on in the time I have on what we have on the different strengths and weaknesses that the two sovereigns bring to it. It may be helpful to So by local, state, and federal, I mean local would be our local in Massachusetts, our local district attorneys. State would be the Attorney General, and federal would be the U.S. Attorney's Office and the Department of Justice. So at least in Massachusetts, and one thing I always like to remember is I think we have people on nationally. Trafficking is an international problem that will require solutions both internationally and nationally, but what trafficking actually looks like varies a great deal from community to community, from town to town, from state to state. So what we have here, so I'm going to really focus on what we have here in Massachusetts. That's where I work and who I've been working with for a long time. Everyone in Massachusetts, in my experience, subscribes to a victim-centered, trauma-informed, culturally responsive approach to prosecuting human trafficking. That's really important. And in fact, my boss is going to speak to you later today. And I'm sure you want to hear from her more than you want to hear from me because she's awesome. And she'll talk more about that. I'm going to talk about sort of how that informs what we do. It's really important because in my view, there's a tension between two of the P's, right? The first P is addressing harm, protection of the victim, addressing harm to the victims. And the second P is prosecution. And we have to acknowledge that prosecution often, perhaps more often than not, does not actually help the victims, does not protect the victims, in fact, often harms the victims. And I've been using the term victim, that's the term that the Department of Justice uses. I acknowledge that, and I think it's important to acknowledge that the people who go through the process are often survivors, and that's the term that they like, that may apply better. I use the term victim because that's the term the statute uses. And so as a prosecutor, that's kind of what the channel I go through. So as a prosecutor,
really appreciate it.
we need to keep we need to keep in mind that what we're doing often makes the victims' lives worse, at least in the short term. So why do we do what we do? Why do we include prosecution as one of the ways to help solve and combat the problem of human trafficking? What are we achieving by prosecution? I think it's important to think about that. So justice, right, which is a broad and sometimes hard to understand term. Justice, I think, more for society than necessarily for the victims or survivors. It's a great privilege and honor when in court to be able to speak for society and say to a trafficker, you can't do that. We fundamentally reject what you've done and think you should be punished for it. I think it also achieves closure for the victims. And I will share with you a quick story, something I observed not more than 24 hours ago. I was in court while one of my colleagues was conducting the sentencing of a really brutal trafficker who'd been out for doing what he was doing for 15 years. One of the victims came and addressed the court very courageously and articulately and talked about her own path a little bit. And she really talked more about the daughter, and this all happened in open court, so I feel it's appropriate to share her story. She really addressed the trafficker's daughter, whom she viewed as a victim as well. At the end of her remarks, she walked out of the courtroom. Now, she could have stayed, and our victim witness specialist walked out with her and came back in. And I sort of asked her, well, where did she go? And she pointed out the victim didn't need to stay anymore. She had said what she wanted to say. She didn't need to see the defendant sentenced. And I thought that was really powerful. And frankly, I'm still trying to wrap my mind around it. What I think that says to us is that for the victims and survivors, the prosecution process might offer closure, but they really kind of make their own peace with it in their own way. So more fundamentally, what do we offer by way of a solution to the problem of human trafficking? I think it gets down to deterrence, both specific and general. Specific in the sense that, taking my trafficker from yesterday, he'll be in jail for nearly 12 years. that's 12 years when you won't be able to traffic anybody else. And secondly, and more broadly, what we provide is general deterrence. It needs to be understood that traffickers bear a terrible risk, that we will catch them eventually, and they'll pay a terrible price. We need to do that to keep them from trafficking. So on the ground, what difference does that make? How does that actually play out in the difference between federal and state? I have maybe a minute left, so I'll touch on this just a little bit. The differences we see in the system are kind of go to the difference between federal and state. On the federal side, we have enormous sentences. The mandatory minimum for trafficking an adult by sex trafficking is 15 years. I'd say the average sentence is in excess of a decade. State sentences are probably going up as well, but they tend to be a little lower. We also, on the federal side, can get traffickers detained immediately, which helps us work those cases and provides a measure of protection for victims while the case is going on. And finally, on the federal side, we have really excellent tools of serving process. We can work internationally, nationally. We can do things like seize Backpage, which happened a few years ago. Those are things that the federal government, I think, brings to it that perhaps the state can't. The last thing I'll note to you is that I really want to emphasize, though, we shouldn't think of the federal government in isolation from the state government. And so I would caution you about looking at statistics, sort of federal prosecutions, at least in Massachusetts, in isolation, because really we work collaboratively with our state and local partners. And you really want to look at what's happening across the whole Commonwealth. So thank you very much for your time. I look forward to hearing from the other speakers.
Thank you so much, Mr. Moran. And so now I think Professor Haynes is back and is able to address us. Professor Haynes? Okay. All right. We are having technology problems. Hi, Arthur.
Okay, we are testing from the hand. So you can hear her?
I can hear now. Thank you.
Okay.
Can you see me?
Yes. We can hear you and we can see you. We are all set.
I am so sorry. I really apologize. You could
no, absolutely
see me
not.
when you didn't want to see me and you couldn't hear me when you wanted to. So let me just go ahead. Thank you for the kind introduction, for all of the introductory remarks. I really appreciated listening to them. Thank you for having me. I'll just jump right in to let you know that I was asked to give an overview of the development of federal and state laws in human trafficking in the US. And given the time limitations, I'm speaking from a sort of 30,000 feet view rather than the sort of detailed critiques I've typically given and written about. I also wanted to thank my co-panelists because the work they're doing is phenomenal, and also to really applaud the work of Professor Dahlstrom and Sherman Stokes, because the work they've done has contributed, along with the Attorney General's office, in making Massachusetts a sort of outlier in terms of correcting for some of the problems that I'm going to discuss here. So in the mid to late 90s, I was heading a human rights department for the OSCE in Bosnia and Herzegovina. And we began seeing indicators of something that looked like what we would come to define as human trafficking. Simultaneously, INGOs and nation states were coming together in Palermo, Italy, to discuss what would eventually become the Palermo Protocol, the human trafficking protocol to the UN Crime Convention. I know some of you are aware of this and some of you aren't, so I'm giving the overview that I was asked to give. At the same time, US legislators were beginning to draft bills and address what would become the Trafficking Victim Protection Act in the US. In the US, prosecutors had been telling legislators for some time that they did not have the legal tools to address the crimes that they were beginning to see, that were coming to the attention of the public as well. For example, in New York, the New York Times had published a story about hearing impaired men and women from Mexico being forced to sell trinkets on the streets of New York City. Initially, legislators conceived of federal trafficking laws that would address what they viewed as a transnational crime and would therefore address prosecuting those who trafficked persons into the United States. This was in spite of the fact that about 10 years prior, a case called US versus Kosminski demonstrated for everyone that there were also insufficient tools for prosecutors to address the abuses in this case, which involved a couple who owned a farm who had engaged two mentally impaired men as farm workers and then used that impairment to effectively entrap them in forced labor for years. Although there was wide bipartisan support, and that's something that still exists, which is quite unique with this particular issue in the United States, the federal law addressing the legislators were quickly moving towards discussions which focused on sex and away from discussions on labor. Eventually, however, the final TVPA passed into law in 2000 addressed both. There are three primary sections which were touched on slightly differently by Attorney Moran a moment ago. We call them the three Ps: protection, prosecution, and prevention. Much of the implementation of the statute that Congress passed, as is always the case, was tasked to executive agencies to dealing with migration. And this is important to what I'm going to talk about now. One of the key provisions, as has been mentioned already, was the creation of the T visa, which was designed to encourage victims to come forward and cooperate with law enforcement towards prosecution of traffickers. And this has been critiqued because it's potentially better observed as a prosecution tool than a protection tool. Although done well, it could be both. So this didn't stop, for example, journalists from calling people like me working on this issue in, let's say, 2001, and asking, didn't I think that the creation of a T visa would encourage people to put themselves in the flow of human trafficking for the benefit of adjusting their status in the United States, to which, of course, I said, given what I knew about human trafficking from working with survivors for many years, this seemed to be a really inappropriate question and certainly not true. But this was a common subtextual thread in the TVPA as well. And the concession was to cap the number of T visas at 5,000 per year. And I and many others who are here today have written about how we've never even come close to reaching that cap, which should cause us to start thinking about the extent to which we actually see and encourage survivors to come forward. The US definition of human trafficking is similar to the definition in the protocol, the exploitation of a person or persons for sex or labor using force, fraud, or coercion, right? And case law interprets that, and reauthorizations have refined that. One thing that people don't readily understand is that the legal requirements for prosecuting a trafficker are different than the eligibility requirements for obtaining a T visa. Not too different, but different enough. To be considered a victim eligible for a T visa, for example, or any benefits that come with that, a person has to have suffered severe forms of trafficking. I'm certain that others on this symposium will go into more on that, so I will just leave it at that. But my point is that there have been difficulties since the beginning with the distinction we make in the US between sex trafficking and labor trafficking. The TVPA, like many federal laws, has sunset provisions and it needs to be reauthorized every 2 years. So over the course of the reauthorizations, Congress, with intense lobbying by interest groups, has begun addressing both real and perceived gaps in the law. Two big shifts that I'll mention here occurred in 2005 and 2008. In the 2005 reauthorization, funding and focus shifted away from migrants and foreign national victims towards US victims. With this, and for reasons I can discuss if anyone is interested, came a natural shift away from investigations of labor trafficking and towards sex trafficking. The 2008 reauthorization and every reauthorization thereafter, perhaps in response to this 2005 shift, came with funding to shift focus to the development of state laws and law enforcement on human trafficking. So from my perspective, these shifts have consequences. They might be positive, they might be negative, but they have consequences. One is that it's truly bifurcated human trafficking around foreign national victims and US citizen victims. If you think about the focus of federal versus state law enforcement, this shift was inevitable. The federal law enforcement agencies tasked by Congress to investigate human trafficking are also tasked with, and in most instances, their primary focus is immigration enforcement. So for example, HSI and ICE can raid a workplace and arrest and detain hundreds of workers for immigration infractions. And yet, even if the tip that came in that justified initiating the raid in the first place was indicating suspected human trafficking, still the federal government doesn't consistently interview those victims to see if they're survivors of human trafficking before they are detained and deported. State law enforcement, on the other hand, historically look for and investigate state-based crimes. And in the course of their daily work, they're much more likely to see crime related to the sex industry than they are crimes related to labor trafficking. Again, Massachusetts, blessedly, is a sort of outlier and has integrated those two in much more coherent ways around some of the early cases in Massachusetts that had to do with domestic household workers of diplomats that caused the federal and state law enforcement agencies to come together to look for human trafficking in different ways that are not as effectively done in other states. So although federal law characterizes its focus through this lens of the 3 Ps, both the federal and state law emphasis has been on prosecution. And for reasons I explained earlier, on the prosecution of sex trafficking predominantly. And by the way, a lot of times both are involved. So looking at them through this bifurcated lens is not typically helpful. When we have focused on prevention, the 3rd P, we've tended to take the locust to the border in the United States through rhetoric and sometimes, frankly, lies about migrants trafficking their own children, or suggesting that if only we could prevent those countries abroad from leaving their citizens imperiled, they wouldn't arrive in the United States to be trafficked. This is wrong and unhelpful, and restrictive immigration laws, frankly, create and exacerbate human trafficking. So I suggest that we take a long look at our failures to conceive of prevention through the lens of systemic socioeconomic problems in the US. For example, right now we have a shortage of teachers in the United States, the big exit, I think it's being called. Several years ago, I worked on representing a victim of human trafficking who was a teacher from the Philippines. Because the last time we had a teacher shortage, what happened? School boards around the United States worked with recruiters, AKA traffickers, to traffic teachers into the United States and leave them basically in forms of debt bondage. So we've been here before, right? We know what the moments are when we need to pay attention. I'm encouraging us to pay attention, to reduce what I have written about as the myopia of law enforcement when they recognize victims of human trafficking. So I see that my time is up. I'll leave it there. Thank you so much. And I apologize again for the technology challenges.
Thank you so much, Professor Haynes, for working through those challenges with us. Okay, so now I have the honor of introducing Elisa Currier-Wheeler, who serves as Associate Legal Counsel for the Human Trafficking Institute, where she directs the Douglas Fellowship for Law Students, co-authors the annual Federal Human Trafficking Report, oversees prevalent studies in Belize and Uganda, and provides leadership for HTI strategic litigation. Previously, she served as HTI's acting special counsel in Uganda. Prior to joining HTI, Elisa was an attorney with the UN High Commissioner for Refugees, where she managed a regional portfolio of migrant petitions for UNHCR assistance. She has represented victims of war crimes before the International Criminal Court and advocated on behalf of forcibly displaced populations with Human Rights Watch and International Justice Mission. Welcome.
Thanks so much. And I echo all the other panelists in thanking Kennedy and Madison and Professor Dahlstrom and the whole Public Interest Law Journal for hosting this great event and for having me here. I am going to be the first to share my screen. So let me know if you can't see it. But at HTI, we really focus on data-driven models for improving anti-trafficking enforcement, and we work with our partner countries to do this. But domestically, what we do to kind of further that aim is we publish the Federal Human Trafficking Report every year, which gives an exhaustive review of every prosecution filed under the TVPA, which you've now heard about. And so I'm just going to give a really quick overview of all of the federal enforcement efforts from our most recent data, which is from 2020. And there'll be some trends, some 20-year trends, as well as we have the data that goes all the way back to 2000 when the TVPA was enacted. So when I'm talking about this data, I'm going to use the terms active cases and new cases. Active cases is the larger pool of cases. It's all cases that were either filed in 2020 or that were filed in prior years and still pending in 2020. And then the subset of those cases I'm going to call new cases, and those are the cases that were filed in 2020. So in 2020, there were 579 cases that were active in federal courts, and 165 of those were new cases that were filed in 2020. And these are including both forced labor and sex trafficking cases, so both types of trafficking that are criminalized under the federal statute. There was an 11% increase in the number of cases that were filed, and this is entirely due to an increase in sex trafficking cases. That follows 2 years of decline. As we heard about earlier, trafficking prosecutions had been declining. So we were surprised to see a small uptick in 2020, given it was in the middle of the pandemic. But again, that was exclusively sex trafficking cases. And in fact, there were more sex trafficking cases filed in 2020 than there were forced labor cases filed in all 20 years since the enactment of the TVPA. And then I'm going to throw in a few Massachusetts specific data points. Prosecutors filed 4 cases in 2020 in Massachusetts at the federal level again, and then all of which were sex trafficking cases. So they were following the trend. Taking a look at the victims named in 2020 active cases, and I do want to just note that we use the term in the report, we use the term victim in the legal sense, that they are a victim of a crime under the law. But of course, we fully recognize that many of these victims are also survivors, and all, of course, are unique individuals that are much more than any label of victim or survivor can capture. But we are kind of limited in the types of terms that we can use in the legal context. And so when looking at the victims in these cases, most were females. And this is especially true in the sex trafficking context there in the ring on the left. And then in the ring on the right, you can see that there were actually more male victims than female victims in forced labor cases. 53% of victims in active human trafficking cases were children, and 47% were adults. Victims' ages spanned 5 decades, with the oldest being 50 years old and the youngest being less than 1 year old. In active sex trafficking cases, the percentage of child victims was 55%, and then it was kind of the reverse in forced labor cases, with 77% of victims being adults. Looking more at the victim demographics, in 2020 active cases, there were 13% of victims were foreign nationals, and 87% were either US citizens or their nationality was unknown. So that's more like at least 13% were foreign nationals. And the breakdown varied a lot by case type. So only 9% of victims in sex trafficking cases were foreign nationals, but at least 57% were foreign nationals in forced labor cases. We also know from court documents that at least 41% of victims in sex trafficking cases were recruited online. And among the adult victims recruited online, most were recruited on WeChat, Facebook, or Instagram. And among children recruited online, the most common platforms we saw were Facebook, Instagram, and Snapchat. And in addition to facilitating the recruitment of victims, the internet is a powerful platform for soliciting buyers of commercial sex. The majority of 2020 active sex trafficking cases involved the internet as the defendant's primary method of soliciting customers to purchase sex from a trafficking victim. And this high percentage is a long-standing trend. Online solicitation has really dwarfed other forms of solicitation for over a decade, as you can see on the slide. But it is important to remember, I always want to note that we're only looking at trafficking that was prosecuted and trafficking that was prosecuted at the federal level. So aside from showing how trafficking is happening, these trends are equally, if not more, reflective of how trafficking is being investigated and how investigators are looking for trafficking, where they're looking for trafficking. And then turning to forced labor cases, traffickers exploit victims in numerous industries, as most of us, I'm sure, are aware. And in 2020 active forced labor cases, the top industries that we saw were domestic services. So that could be anything from nannies to housekeepers. And then the restaurant or food services industry was another top industry, agriculture, beauty services, construction, manufacturing, and the hospitality industry. And these are generally the same top industries that we've seen since 2000. Most of the human trafficking investigations that resulted in federal prosecutions were investigated by the FBI, and then 37% were investigated by Homeland Security investigations. Then the remaining prosecutions stemmed from investigations by the Drug Enforcement Agency, Diplomatic Security Service, and U.S. Marshal Service. And I will note that HSI every year is involved in more forced labor cases and sex trafficking, and then it's the opposite for the FBI. Most sex trafficking cases filed in 2020 were against a single defendant, whereas most forced labor cases were against multiple defendants. And based on our review, the largest case in 2020 happened in the Eastern District of Virginia, which was a gang-directed sex trafficking case that involved 11 defendants. In 2020, the conviction rate dropped below 90% for the first time in 8 years, with federal courts convicting 89% of defendants at the district court level. And in Massachusetts, there were only 2 convictions, but there was a 100% conviction rate. And since the TVPA's enactment, federal courts have steadily increased the severity of sentences imposed in human trafficking cases, up to an average of 156 months in 2020. And both of Massachusetts convicted defendants were sentenced to terms of imprisonment with an average prison sentence of 138 months. Defendants convicted under the TVPA are subject to mandatory restitution, which is often essential for assisting survivors to rebuild their lives. However, judges often fail to order defendants to pay mandatory restitution. And of defendants subject to mandatory restitution in 2020, only 50% were ordered to pay, even though it's mandatory. In years past, the restitution rate was much lower in the sex trafficking context, which could be due to more challenges in calculating victims' losses in sex trafficking cases. And unfortunately, in Massachusetts, there was a 0% restitution rate in 2020 at the federal level. So that is just a really quick overview of the federal human trafficking, anti-trafficking efforts. 2 main takeaways that HTI really likes to emphasize is we just would really like to see an increase in forced labor prosecutions and a greater focus on that, not to the detriment of sex trafficking prosecutions, but we would like to see an increase there, and then restitution as well, an increase in mandatory restitution orders. So thank you for having me again.
Thank you so much for being with us. Okay, so now I'm going to introduce our last speaker, and then I see that we already have some questions, so that's great. So Sabrina Talukder currently serves as a federal policy director of the Sunita Jain Anti-Trafficking Initiative at Loyola Law School. Prior to this position, she completed a fellowship with the Legal Aid Society in New York that enabled her to work out of Rikers Correctional Facility and represent immigrant survivors of human trafficking and domestic abuse. After completing the fellowship, Talukder continued working for the Legal Aid Society, first as a staff attorney and later as an immigration and trafficking expert. Welcome and thank you so much for being here.
Thank you all so much for having me. Thank you to my fellow co-panelists for your incredible work that you're doing, and to Boston University and the Public Interest Law Journal for inviting me to this incredible event. I am also going to share my screen for a little PowerPoint. Okay, great. Can everyone see it? So thank you again. My name is Sabrina Talukder. I am the Federal Policy Director at the Sunita Jain Anti-Trafficking Initiative. And the initiative is based at Loyola Law School, and I am starting our satellite policy office in Washington, DC. And prior to that, I was lucky enough to work at the Legal Aid Society in New York City. I represented incarcerated and detained human trafficking survivors who were immigrants upon felony arrest, and I had the honor of representing them in their criminal and immigration legal proceedings. And I wanted to note that I left my job at Legal Aid, which is a job that I cherished and truly considered the greatest honor of my life, because my clients were falling through the cracks of the anti-trafficking policy regime. And I wanted to shift to policy to really look into the differences between state and federal work in combating trafficking. And at the Sunita Jain Anti-Trafficking Initiative, we are a little unique. We are an evidence-based and community-informed think tank that intentionally fills gaps in the human trafficking prevention world. And what I hope to do today in our presentation is to talk really about three things. The first is, with the laws that we currently have and within our current anti-trafficking policy regime, which survivors are truly being protected and why? Who is entitled to access legal protections and benefits? And really at the heart of that question is, which survivors are we really caring about? The second is, what kind of work can be done to fill the gap between state and federal efforts? And the third, with all this knowledge that we have about the gaps that exist and the incredible coordination as well, many times between state and federal work, how can this apply to preventing trafficking, especially from an intersectional lens? And one example that I just hope to talk about in terms of gaps that exist between federal and state work and how that impacts survivors directly, based on my experience, is with vacature. So for me, many of my clients, they're very different from the mainstream narrative of human trafficking. My clients were at the intersection of both criminal and civil enforcement systems. They engaged many times in forced criminality that fell outside of what we think of trafficking survivors. They committed harm to others. Many times they trafficked others, but this still never negated the fact that they qualified as trafficking survivors many times over under the TVPRA and under the New York statute. However, despite the fact that they were trafficking survivors, because of how they entered these enforcement systems, or because of how they were detected by US citizens or people working within various agencies, they were never screened for trafficking or exploitation. And that's for several reasons. They fell outside of the mainstream narrative. Forced criminality is rarely articulated as labor trafficking by people on both sides of the issue. And because of that, my clients had felony level convictions or other kinds of convictions that were directly or indirectly connected to their trafficking experiences. For folks that were non-citizens, for people trying to move on to their lives, do something as simple as apply to school, get a GED, take English as a second language classes, these convictions proved a bar for them to move on from the economic, political, and social circumstances that made them vulnerable to exploitation and trafficking in the first place. So for me, when I started, I was in a unique position to be kind of working within New York State criminal law, but also, of course, within the federal immigration laws. And what I found was that the gaps really illustrated which survivors are entitled to protection and why. On the federal level, there is no federal vacatur remedy for folks convicted of federal convictions related to their trafficking experiences, despite the fact that there's really a plethora of intent articulated within the INA, within the congressional testimony in the Trafficking Victims Protection Act, and in a variety of other ways as well. However, despite all of this good intent, there's still nothing on the federal level that can allow someone to move forward with their lives if they have a conviction. And what I have found on the state level is that there are discrepancies within state vacatur statutes themselves that illustrate who has access to protection. In New York, before the passing of the START Act that just happened, the emphasis was on sex trafficking and not labor trafficking. Most of the time, for example, in California's vacatur statute, only misdemeanors can be vacated and not violent offenses or felonies. And that applies to expungement, convictions, resentencing. And what I have found as an immigration attorney is that there's very little crim im analysis that happens while the legislation itself is being drafted. And that matters because vacatures, even if a non-citizen is able to get their conviction vacated, which is incredible, the vacatures still have to go through a separate analysis for immigration purposes. And for me in particular, and for my clients, it really underscored that the person who's really protected, the survivor, is one that fits the mainstream good victim narrative. It's rarely a labor trafficking survivor, especially if that person has been convicted of an act of forced criminality. The misdemeanors that my clients at least were convicted over were prostitution or petty larceny. It doesn't really fall under a large range of misdemeanors. And my clients, especially in the prior administration, the questioning that they received regarding the validity of their vacatur and whether or not it was rehabilitative, I would say it happened in like 98% of my cases, such that I had to file vacatures under another section of the New York State statute that was not for trafficking survivors, but more under a legal defect ground, in order to ensure that I kept their removal proceedings as short as possible. And that's been my experience. And what I am hoping to work on at the Sunita Chain Anti-Trafficking Initiative, and as a potential solution that I hope could be a model, is for a federal vacatur statute to really just serve as a model for states and for survivors as we try to move forward. I know that a lot of states are, with this new administration especially, are reintroducing legislation. California is, New York just did, to really try to hone in on the gaps that exist within their own vacatur laws in their states. And what myself and other coalition group members are working on is the federal vacatur model, where there would be an affirmative defense to trafficking, that it would expand to both misdemeanors and felony offenses, have lower standards of evidence, and include criminal specialists from the beginning to ensure that it's not viewed as rehabilitative. And there are other examples of this as well. When there are gaps that exist between state and federal protections for the most vulnerable people. Right now in California, especially, the cannabis industry and labor exploitation, there's such a gap between federal oversight and protection for vulnerable workers that fall outside of California's worker protection, that we've seen a lot of folks who are undocumented and non-English speakers be exploited within this realm. And this has been brought up before as well, but the role of ICE and HSI and their interactions with the criminal legal system is also a huge gap that directly affects trafficking survivors. I've personally had clients not go to immigration court or criminal court and receive warrants and orders of indicia because they were so scared of ICE being able to come to court, especially if their charges fell outside of, in New York, fell outside the Secure Communities Agreement that would allow ICE to come. And what I hope is that when we talk about prevention, specifically for trafficking survivors, that we're able to apply an intersectional lens. And I think within this administration and within our state work, we're able to do that. And these are just some of the pillars that our initiative was working on. But for the students in particular, I wanted to end on a positive note, which I feel like as a new policy director is really missing. And really that we're in a historical moment where we're shifting from a purely enforcement lens to something that is more public health and intersectional. And I hope that no matter what you decide to do, no matter the work, that if you want to protect vulnerable communities, that in and of itself is protecting the potential of someone to be, that is preventing someone from being exploited. And I would love to talk about climate distance trafficking, but I think I will at a later time. But I'm always available for students if they have any questions or concerns. And thank you again to Boston University and for my esteemed panelists for having me.
Thank you so much. We really appreciate that. So now I actually have some audience questions. So I would ask the panelists to come back on screen, maybe, so I can just get some. Thank you so much. Wonderful. Okay. So I will start with a question from, and I apologize in advance if I'm not pronouncing correctly someone's name, from Chuck Dunham. So here's his question. Hello, I'm a juvenile probation officer in Berkshire County. I am part of the CSEC team. The team met yesterday regarding a young lady who is involved in our system. It was clear that our county has very limited resources to help her and others who are in her situation. How do we get resources to our county to help the youths that need it most? So that question is for any panelist.
Well, I don't mind starting. I might offer, when he says a CSEC team, he's talking about a sexual exploitation of children. And one thing I'll highlight is that in Massachusetts, through the efforts of some stakeholders here, all the district attorneys have adopted a multidisciplinary approach such that when there's a report of trafficking targeting a minor or any sexual exploitation, they form a team consisting of the district attorney's office, the Department of Children and Families, that person's personal social worker, if that person has any other representatives, even that person's defense counsel, if that person is already involved in the juvenile justice system, and it might involve mental health or physical health practitioners, with the idea of getting that person the stuff that they need. What is Berkshire County, where I think he's calling from, is a challenge, especially in, we have resources and a wider range of resources in the Boston area, but especially Berkshire County's Western Massachusetts, more sparsely populated, and I'll say especially in the LGBTQ community, if we have victims and survivors, especially juveniles, that's a much harder niche to fill because there simply aren't the resources, particularly among mentors. And you see that I mentioned trafficking patterns. Berkshire County actually aligns more directly geographically with, say, New York City. And so one suggestion that we've been thinking about, and I'll say that there are others working, really talented people who are including people on this call who are working really hard to solve this problem. I think one solution is to think more regionally. Like I said, Berkshire County actually is probably closer to New York City than it is to Boston. And we need to think more broadly about linking up regions is one small suggestion, but I'll acknowledge that's a really difficult problem, but that we are working on it.
Great, thank you. So I have a question here from another audience member, Susan Powell. She asked, I'm curious what the panelists think about sentencing as a tool for deterrence. Is the consensus that increasing severity of sentences is indicative of a better response to trafficking? Or are there other indicators that better measure the effectiveness of our anti-trafficking efforts?
I will jump in here. I am not going to try to say that I can prove that deterrence works. That's a whole debate that could last a very long time. But I will say there are other indicators of whether interventions are working as well and enforcement efforts are working. One of those is prevalence, whether the prevalence of trafficking is decreasing. And that's something that is very difficult to measure. In fact, there are very few good prevalence estimates that are reliable out there. So always be very cautious about prevalence numbers when you see them. But there is fortunately a movement in the anti-trafficking space towards more reliable prevalence estimates, looking more geographically focused or looking at a specific industry in order to be able to measure the success, not just of prosecutions or sentencing, but all different types of anti-trafficking interventions, including public health types of programs and spanning the 4 Ps that we've been talking about: prevention, protection, and prosecution. So certainly not the only way to measure the success of anti-trafficking efforts.
I can add this as well as a person who has asked for long sentences against traffickers. It's an important point to talk about whether the length of the sentence accomplishes general deterrence. There's some research showing that it's the certainty and the swiftness with which punishment is imposed which generates general deterrence, by which I mean deterring other members of the public who might think about getting involved, not the specific defendant there. I do think that the long sentences accomplish a different thing in this context. One is specific deterrence, by which I mean by the time a trafficker gets to federal court, that person often has been involved for a long, long time. We prioritize in the federal system in Massachusetts sort of the hardest cases, the most broadest traffickers, things like that. So they often get to us having not been deterred by previous sentences. And so we're thinking in terms of reducing the harmfulness of that person going forward. And the other thing is that the longer sentences also, I think, attempt to express the public's real disgust with this crime. And so you do definitely see on crimes that are so morally abhorrent, longer sentences. But it is an important conversation that I think the Justice Department and the criminal justice system is starting to have.
I would add that I'm guided by the experiences of my clients. And I think that it's extremely nuanced, as Attorney Marion had brought up, that every survivor's experiences with their traffickers and what their wishes are and how they find closure is extremely unique to them. And it may be through restorative justice. And there's so many different ways to go about this. I think the question that I would add is whether, in terms of deterrence and recidivism, is will the person come out in a different situation from when they entered, or what would have led them to begin a life of forced criminality? Is their situation going to be any better or any different? They return to that life because they're in the same circumstances, etc.
Okay. I'm looking. There's a lot of great questions, so I'm trying to respond to provide you with one of them. Okay, so here's a question from Edgar Cruz, and I think we have a little bit of time. We have like 3 minutes left. Edgar Cruz, how can we support a multidisciplinary team response to address child trafficking and exploitation? How can the justice system continue to support not just the prosecutorial priorities, but also the protection of the child, recovery, healing, and access to mental health services? in 3 minutes.
I'll just say one slice of this, and I responded to this on a different question that the same person asked, is that if you're talking about foreign nationals, disaggregating the immigration consequences from the protection and services offered is really important. So in other words, a child who has no status needs to be in a protected system where there are no consequences to, for example, seeking a T visa or special immigrant juvenile status or some other protection. Our laws are written well to provide that, but in practice, it's not where it needs to be.
Thank you so much. So I think that if no one has anything left to this question, then I actually saw a question that was specifically for Sabrina, and maybe I'll ask it in the 2 minutes we have left. It says, Sabrina, in the coalition work to fill the policy gaps in protection, what are the efforts channeled directly towards the immigration enforcement issues?
That's a great question, and I definitely invite the other panelists to speak on this as well, because as we saw in both the Obama and Trump administrations, that there was extensive advocacy and work being done about the criminal to deportation pipeline. I think this administration in particular, when it comes to trafficking survivors, has really articulated specifically within their ICE and DHS enforcement memos protections for people who identify as survivors and able to provide credible proof that they are survivors. And that has, in the few months I worked directly in removal proceedings during this administration, it completely changed everything for me. Those caveats and protections allowed, it was a gap that was filled, specifically those enforcement priorities. I would love for other panels to talk about what's happening in Massachusetts and Boston. I could say that the Crim-Im policy world that really addresses how someone enters, how a non-citizen enters either of these enforcement systems is really, I think, incredible and well articulated in covering and taking an intersectional approach to racial equity in immigration, that whole part of it. But the groups that I think are incredible are Immigration Defense Project in New York City, ILRC, PILJ, and so many others. And I'm happy to direct you to them offline as well.
So thank you so much. To everyone, to all of our panelists, thank you so much for all the really wonderful questions from the audience. We apologize that we could not get to all of the questions. Obviously, there's a lot to talk about with this in terms of the federal versus state efforts to combat human trafficking. We invite you back for our next panel, which is on creative litigation efforts to support human trafficking survivors. We will be back at 11:35. Thank you, everyone.
About creative litigation efforts to support human trafficking survivors. We could spend our entire time just talking about that title of the panel, right? So thinking about creative, thinking about the innovative way that advocates on this call, both advocates in community, advocates within the legal system, are addressing this issue. And thinking about how it's being addressed through litigation, criminal and civil, and thinking about how this supports human trafficking survivors. And so often when we're thinking about the litigation process, the legal process is often not supportive. The law can actually be a location of really re-victimization for survivors in a variety of contexts. And so it's exciting to think about the ways in which the law really is supporting survivors and also the ways that the law really needs to change. And so I'm particularly excited about this panel because of really the vast knowledge, the vast experience of the individuals here. So what we're going to do is we're going to proceed. I'll introduce one of the panelists. They'll speak for 8 to 10 minutes. Then we'll proceed through the group and then have an opportunity for our question and answer discussion. So each panelist will have 8 to 10 minutes. So without further pause, I want to first introduce Nicole Bell. And Nicole Bell is a human trafficking survivor and an activist. Notably, she is the founder and chief executive officer of Living in Freedom Together Incorporated, LIFT, which is a survivor-led nonprofit dedicated to helping individuals exit and recover from commercial sex exploitation. She is also co-chair of the Worcester Alliance Against Sexual Exploitation, on the Executive Council for World Without Exploitation, and appointed to the Executive Office of Public Safety's Justice Involved Women's Committee. So welcome, and we look forward to hearing your comments.
Good afternoon, and thank you, Jasmine, for the introduction. I'm grateful to be here amongst friends and colleagues and those looking to learn more. So as Jasmine mentioned, I am the founder and chief executive officer of an organization called LIFT. We're located in the Central Mass area, and we support all survivors of commercial sexual exploitation and prostitution in varying ways through different programming, residential programming, low barrier shelters. And one of the most significant barriers that we face in helping people move forward is the criminal record that comes with being prostituted, trafficked, and exploited. And I will share that I myself, when I exited the life 8 years ago, exited with a significant amount of trauma, a significant substance use disorder, and also a significant criminal record that contained over 20 prostitution charges and convictions. So first I want to start by saying, I was able to get my record vacated with the help of a law firm in Boston, but most folks don't have access to those resources. And I also just want to say that though I'm grateful the vacature law exists, but it's also a really traumatizing and burdensome and arduous process that we should not have to go through in order to move forward. We don't think about the way criminalization of survivors of prostitution affects people. It prevents us from accessing safe housing, from accessing employment. And even for me, my children, like if I wanted to attend my son's field trip, right? They would run a query check on me and, I would be identified as somebody who had been prostituted to my son's teachers in school, right? And so thinking about the ways that impacts folks. And so, again, grateful that vacature law and relief exists in Massachusetts. I feel it is not broad enough and does not encompass the additional crimes that we need it to. Oftentimes, survivors like myself are forced to carry weapons for our traffickers, are forced to carry drugs for our traffickers, and those laws are not eligible for relief, under the current existing legislation. Myself and other survivors across our state, as well as different activists, worked together this last legislative session to put forth a bill called an Act to Strengthen Justice and Support for Sex Trade Survivors. And I believe this is what we need to do to move forward. This bill was a comprehensive and an innovative approach to prostitution. It would decriminalize those who are being prostituted, who represent some of our most marginalized community members, and expands access to resources for those who want out, right? While maintaining existing anti-trafficking laws. The bill would decriminalize people in prostitution, so it would repeal the crime of selling sex, including common night walking and street walking. It would advance criminal justice reform. It would automatically expunge the criminal records of trafficking and sex trade survivors for all previous prostitution charges. And it would implement a sliding scale fee collected from buyers and directed to MOVA to then fund exit services. And I think most importantly, it would establish an interagency committee across our state that would be operate under the Executive Office of Health and Human Services. And it would include survivor-led organizations, government agencies, MOVA, those providing mental health services, housing, children and families, LGBTQ+ organizations, healthcare. And the goal of this committee would be to bring people together to kind of close on ramps into prostitution and also open off ramps, right? So investing in supportive housing, job opportunities, education, treatment for substance use disorder and health services. The committee would be tasked with coordinating prevention and awareness campaigns and addressing long-term housing needs and employment needs. Unfortunately, we filed this legislation at the beginning of 2021. It did not pass this legislative session. That does not mean that our work stops. We are continuing and we will be refiling. But, over the course of the year, I will say, first of all, this was historic and critical legislation. It was the first actual survivor-led legislation, equality model legislation that has been introduced across our country. Oftentimes, the reality is we often don't include survivors in these leadership positions and believe that we're capable of driving legislative change. We are. Survivors were, a critical voice in writing this legislation, in filing this legislation, and attaining co-sponsors. And also, we built a really broad coalition of support. We had, multiple district attorneys, including previous district attorney Rachael Rollins, Joseph Early. We had labor unions, sexual assault and domestic violence organizations, faith organizations, BU Immigrants and Rights Trafficking program. And we really worked hard to kind of, help educate folks on why this legislation is important to prostituted people. I will say it was really disappointing when this law didn't pass. Legislators often don't understand that when people are bringing bills forward like this, it's because it impacts real people's lives. And I will say, as amazing and strength-based as the work that we do at our programs is, the reality is we have houses full of women that are just stuck and survivors that are just stuck because their criminal record is preventing them from accessing housing and employment and moving forward. And also this legislation would have helped with like this cultural shift, right? The reality was I, had 22 prostitution convictions, that I was arrested over 40 times. And most of my arrests occurred while I had a third party coercing and trafficking me. And never once did anybody within law enforcement say, do you need help? Would you like to exit? Is anybody forcing you to do this? It was always looking at me like, what's wrong with me instead of what's happened to me. And I think this legislation would help shift people's understanding that entering the sex trade is not it's not a choice that we're making, right? Choosing prostitution is a pretty privileged choice to make. The reality is most who end up in prostitution are those with the fewest amount of choices. We really need to work to shift cultural attitudes and help people understand that it's not okay for white men of means to buy access to the bodies of predominantly Black and brown girls and LGBTQ+ youth in our communities anymore. And this is an important legislation that we should be prioritizing in order to help our most marginalized community members access the resources and support that they need. I see that I'm pretty much out of time here. I don't want to, take anybody else's time, but, I thank you for having me. And again, we look forward to getting support from our partners to get this bill passed and make a real impact in survivors' lives going forward. So thank you.
Thank you so much, Nicole. This is really powerful to hear about the work being done, and really devastating to hear that there's so much more work that needs to be done, particularly around these proposed legislative reforms that need to happen. Let's move now to Ashley Pelto, who is a 2020 Equal Just Works Fellow in the Legal Advocacy Program. Her research centers on the intersection between domestic violence and human trafficking. At University of Michigan's Law School, Ashley served as a student attorney in the Human Trafficking Clinic and as a Douglas Fellow for the Human Trafficking Institute. She chaired the law student organization, Human Rights Advocates. And prior to law school, she volunteered with the Montessori Project, a safe house for teenage survivors of sex trafficking, as well as her undergraduate university's chapter of International Justice Mission. We look forward to hearing from you, Ashley.
Thank you, Professor Gonzalez-Rhodes, and good morning. Just to clarify, I do work in a legal advocacy program of an organization called DOVE, based in Quincy, Massachusetts. And my focus for today's panel is going to be on the topic of criminal record relief as well. So I am going to share my screen, just have some slides. All right, and I just wanted to know, it's been really great to hear from some other panelists, from Nicole on her experience going through the record clearing system, but also in her current policy efforts, right, with her organization in this area. And then also Sabrina in the previous panel discussing vacature with the client population that she works with. And so I'll just be speaking on my experience in criminal record relief work as an attorney in Massachusetts. And so I'll be focusing on the experiences of survivors' interactions with the criminal legal system as defendants, and my knowledge of what practitioners in Massachusetts are doing, through using record relief to try and remedy wrongs committed in that area. So just to start, as we know, in the legal sense, human trafficking is often divided into two separate categories, labor trafficking and sex trafficking. And what we also know is that the manifestations of what trafficking actually looks like are incredibly varied and diverse. The National Human Trafficking Hotline has been operating for over a decade, and Polaris has analyzed the data that they've received from calls and texts over the years. Of the populations who've reached out to the hotline, Polaris has identified over 20 typologies of trafficking that callers have experienced. Sex trafficking, based off hotline reports, can look like outdoor solicitation and escort services, but it can also look like remote interactive sexual acts and personal sexual servitude. Labor trafficking can occur through a broad range of industries, from those involving manual labor, such as forestry and construction, to specialized fields such as healthcare or education, as was mentioned in an earlier panel. From this, it is fairly easy to conclude that the means traffickers are using to control their victims are diverse and nuanced, depending on the industry or business model that they are exploiting. We also know that the failure of systems in our society create risks for certain populations. And so populations which intersect with these societal risks are often more likely to be the targets of traffickers, since traffickers are aware of vulnerabilities created where systems fail. And so it's the belief of many practitioners that populations that have experienced marginalization from society are the targets of trafficking and exploitation more often than those in the societal majority. And so I'll reference some of that practitioner support here, where we can see this disparity showing up as it relates to racial and social populations. So Cheryl Nelson Butler wrote in her article, The Racial Roots of Human Trafficking, that while Black children are more likely to experience some form of sex trafficking, other children of color are similarly at a higher risk than their white counterparts. Native Americans in particular argue that a strong connection exists between colonization and a persistent targeting of Native people for prostitution. Lambda Legal writes on their website that LGBTQ people who are arrested on prostitution-related charges are more likely to carry the long-term effects of criminal record creating barriers to housing, services, and the formal economy. And Rights for Girls Racial Justice Fact Sheet writes of the population that they serve, that Black adults account for approximately 37% of adult prostitution arrests, more than any other racial group, and that Black children account for nearly 53% of all juvenile prostitution arrests, again, more than any other racial group. And so just as traffickers are able to exploit societal risk factors to bring their victims into a trafficking scheme, those same risk factors impact the arrests, charges, and convictions of certain marginalized populations within the already vulnerable population of trafficking survivors. In 2016, the National Survivor Network released a survey it had conducted of 130 trafficking survivors. Over 90% of survey respondents reported that they'd been arrested at least once during the course of being trafficked, and over half believed that 100% of their arrests, charges, and convictions were directly related to their trafficking experience. Based off what we know about the variety of typologies and tactics that traffickers employ, we see that these charges can vary widely in nature. And in fact, the Freedom Network Survivor Reentry Project wrote in its guide to attorneys who are advocating for survivors with records that for sex trafficking victims, these crimes are frequently prostitution charges, as we just heard Nicole discuss. But also, as she just shared, they may also include other charges such as weapons and drug carrying offenses, financial crimes, identity theft. Labor traffickers, like sex traffickers, can also benefit from forcing a victim to commit illegal acts, such as selling or cultivating drugs, or commonly at the US border, forcing individuals to be drug mules or to bring people into the country unlawfully. Additionally, other common offenses for labor trafficking survivors can include possession of false ID documents, financial crimes, or other minor offenses such as trespassing. And youth who are trafficked are often charged with status offenses such as truancy or running away. If a person is not identified as a victim at the time of arrest or prosecution, the frequent result is that their trafficking experience ends with a criminal record on top of the myriad of other traumas that they've endured. The records that result from these arrests and convictions can impact survivors' lives for years after they're able to exit their trafficking experience. A survivor with a record may face rejection from a job or housing application when a potential employer or landlord discovers the conviction in a background check, thus barring them from finding gainful employment or affordable housing. The National Survivor Network survey found that of the 91% of respondents with convictions on their records, almost 73% faced barriers to employment and over half faced barriers with housing. Survivors with records and convictions may also be disqualified from financial aid and private loans if they seek to continue their education. They may lose or be unable to regain custody of their children. They may not be able to access government benefits, or they may face removal or be barred re-entry from the country if they're a foreign national with a criminal conviction. From this, it is abundantly apparent that the incursion of records is a frequent issue that trafficking survivors face during and after their trafficking experience. There is a remedy for survivors available at the state level who have incurred such records, and this comes in the form of record relief, which provides an avenue for survivors to clear their records of charges obtained from crimes that traffickers forced, coerced, or compelled them into committing, or which they committed as a means of survival or coping. There are three primary forms of record relief: record sealing, expungement, and vacature. So sealing is the least effective of these options when it stands alone, because the conviction remains, sealing only hides it from public view. And while a sealed conviction would not turn up on a background check, a court order can still allow a party access to a sealed record. Records that are expunged while inaccessible to the public can remain visible to certain government agencies, and so prosecutors have the option of using the conviction against a survivor in later legal proceedings. Vacature, particularly when it is paired with automatic sealing, is the most effective of these three options for a survivor because it exonerates the survivor of any guilt and can remove every trace of the record from the system, because once a conviction is vacated and dismissed, all records of it are deleted, as it no longer exists as a matter of law. Vacature that is based on the merits in the statute's language is the strongest form of relief because it's acknowledging and confirming that the vacature was due to a substantive defect in the judgment against the survivor in the first place. What many states have done is created specific legislation, which makes record relief more easily attainable for trafficking survivors, so that in some circumstances, survivors do not have to rely on general record clearing laws. In 2010, New York became the first state to create a law that specifically allowed survivors of trafficking to vacate prostitution charges that were a result of having been trafficked. The law became a model for legislation in other states to follow, and at this point, all but 3 states and the federal government, as Sabrina alluded in the earlier panel, have followed suit and have some form of record relief on the books for trafficking survivors. Just last week, New York passed an update to their law, which makes them the first state to allow survivors to vacate any conviction that they received, regardless of the nature of the offense. And so, as we just discussed earlier, this is the ideal statute for survivors, since we know that traffickers can cause their victims to engage in a wide variety of criminal conduct as part of their trafficking scheme. In 2018, Massachusetts created its first record relief law specifically designed for survivors, MGL Chapter 265, Section 59. And so underneath Section 59, survivors of trafficking may file a motion to vacate convictions for prostitution-related offenses and simple possession of a controlled substance, those 2 categories. However, if a survivor is charged with a crime outside of that short list, which as we know they frequently are, or if the charge was anything other than a conviction or a continuance without a finding, survivors are bound by the limitations of the general record clearing laws. Some practitioners in Massachusetts have used Massachusetts Rule of Criminal Procedure 30B to make a creative vacatur argument for convictions outside of Section 59. However, a straightforward vacatur law like the one New York has, and preferably one that automatically seals vacated records, would be a start in best practice for the state. Although I think if we're dreaming big, best practice would mean that survivors are being identified at the time of any interaction with law enforcement, so that these charges are not being incurred in the first place and they're not having to go through this entire record relief process. So then just finally to wrap up, there are a number of practitioners throughout the state thinking critically about what this would look like in legislation. As Nicole just named, LIFT and the host of organizations working together on this recent bill, as well as other areas of legislation. And so we're hopeful that as changes taking place in this area throughout the country, that it can continue in Massachusetts as well. And what I have listed here are organizations actively engaged in providing legal services for record clearing for survivors. Thank you.
Thank you so much, Ashley, for providing this overview of types of trafficking, of relief that's available under the law, and also organizations that are working to address this. I know I'm starting to think of questions that I want to ask our panelists, and I want to invite the audience to add their questions to the Q&A function. And so now I would like to move on to Beth Healey, who is the Chief of the Human Trafficking Division at the Massachusetts Attorney General's Office, where she handles high impact, multi-jurisdictional human trafficking investigations and prosecutions, and focuses on policy, training, and prevention efforts across Massachusetts. She has investigated and prosecuted numerous organized criminal enterprises. Prior to her work in this particular role, she was an assistant district attorney at the Suffolk County District Attorney's Office in Massachusetts. Thank you for joining us, Beth Healey.
Thank you. Get the mute going there, get it off. So, all right, thanks everyone. Thank you, Jasmine, for that kind introduction as well. And I'm so thankful to be here with all of you today. Thanks to BU and everyone at BU for putting this day together, and for all of you that are here and engaged on these issues surrounding human trafficking. So yes, I'm Beth Healey. I'm an assistant attorney general, but I also head up AG Healey's Human Trafficking Division. And I think as part of my role in this panel, I'm going to tell you a little bit about my role and really how we approach our work at the Massachusetts Attorney General's Office. So, as a prosecutor, the litigation we are primarily involved in is criminal prosecution of sex trafficking and labor trafficking. So that means we work on bringing state sex trafficking and labor trafficking cases But as you heard at the Attorney General's office, we're also focused on prevention efforts, policy impacts, assisting with training and awareness building opportunities. At the Attorney General's office, under the Criminal Bureau at the Human Trafficking Division, we actually have 4 Assistant Attorneys General focused on anti-trafficking efforts in our state. And we work with Massachusetts State Police that are assigned to work with us on investigations. And we also have financial analysts, digital analysts that work with us, as well as victim witness advocates. So that's usually what comprises our team when we're thinking about an investigative team. And we're focused on bringing and building strong cases with substantial evidence in order to hold traffickers, exploiters accountable. And at the outset of a trafficking investigation, we assemble that team, right? At the very beginning, we put together a police investigator, a prosecutor, and an advocate at the all together, leveraging the strengths of their respective disciplines to start at the beginning on thinking about how they're going to approach a particular scenario, right? So that team will then analyze whatever facts they have against our laws, right? See what we can do and potentially, what needs to be done in order to move forward with an investigation and connect with resources when we can as well. So, as we're beginning an investigation, we think about what we have, how we can build a case. And when we connect with those that are victimized in our investigations, at the outset, we let them know we are not looking to arrest them. Our approach is not to arrest those that we find victimized in trafficking situations, but rather to tell them we're that, and that we're focused on those that are exploiting them, right? And, we talk about our approach in these investigations and prosecutions. We want this work to be trauma informed and victim centered. And we also acknowledge that engaging with the criminal justice system can be infused with trauma for survivors, right? Sometimes it can be empowering for folks to come forward and speak with law enforcement and testify, right? But it can also be incredibly difficult and bring back trauma, make folks feel like there are additional consequences in the moment, right? So as prosecutors, we work to acknowledge this inherent discomfort, right? And this tension that exists in prosecution work, along with our focus of trying to keep folks in the community safe. So in Massachusetts, as state prosecutors, we operate under statutes that are considered to be a bit broader than the federal law. The legislature did this in our state intentionally, I think, to allow us to cast a bit of a wider net than our federal counterparts. And so, at the Attorney General's office, our cases do often involve several counties, several defendants, perhaps several victims or survivors in one particular scenario we're investigating. And we're able, with our ability to convene a statewide grand jury, which allows us to try and streamline these investigations so we don't need to have duplicative testimony. The process of our criminal cases, though, takes time, and we know that as also can feel like a burden, right? Survivors may be in a different place along the way of any criminal investigation and prosecution, and certainly when a case gets to trial. And so we know it's important to keep open lines of communication with the witnesses in our case so they understand, know what's going on with this work that we're doing. So ideally, so they're not taken by surprise, so they can grapple with the progress of the case for themselves. With our investigations, we work to build, as I mentioned, strong cases with corroborating evidence, additional testimony so that survivors don't need to feel like the entire case rests on their shoulders. Ideally, so that we're not in a position to rely so heavily, or ideally, maybe not at all, on survivor testimony at a potential trial. While that's not always possible, it's really our goal and what we strive for in our cases. And we want to support survivors along this difficult process. So towards that goal, we are connected in our approach with direct service providers across the region and the state, and we look to those agencies for assistance in order to build our cases. We look to them for input on how to just approach, our work as law enforcement. We know we need that. We're partnered with agencies like Nikki at Lyft. We know they can offer support. We can't, and we really can't do our prosecution work without that partnership. So at the Attorney General's office, our approach is also to think about ways outside of the prosecution where we can make an impact, right? So, sometimes it's by listening and not moving forward with a potential investigation or case, but seeing if there's other ways that we can help. Sometimes it's our approach in being ready to certify UNT visa requests, even in instances where prosecution is not proceeding, right? It's our approach in working with local law enforcement to reconsider how they have approached, situations of trafficking and prostitution in the past, and to encourage them, to train them, to reconsider that, to understand what it means to be trauma-informed, to grapple with that, and to encourage them to think about language, how that matters all the time, right? And working with our resource providers, other civil legal advocates to think creatively about ways to make an impact in the community. In the labor trafficking context, at the AG's office, we've partnered with our Fair Labor Division, and we've been we have a strong partnership with that division that does both civil and criminal enforcement of wage and hour laws. But we've been able to evaluate situations alongside of our Fair Labor Division around potential labor trafficking investigations and alternatives, right, to consider immigration relief options or civil enforcement in appropriate circumstances. We've also worked with them quite a bit on building awareness around labor trafficking in our state, and initiatives we've done together include, have been aimed at educating folks working in the communities outside of law enforcement and community groups. So in the past, we've also, done some work connecting with the business community and connecting with employers to raise awareness about, the intersection of, what business leaders can do to raise up awareness with their employees and consider their HR policies to refocus them to understand the harms of sex trafficking and prostitution. And most recently, we've received a federal grant from the Department of Justice to create what's called an enhanced collaborative model task force. This is our Commonwealth Anti-Trafficking Task Force you may have heard mentioned earlier today. And the goal of that task force has been to formalize this Attorney General's office approach that we've had for a couple of years to criminal cases and to better it, ideally, as well to use this task force to think about, outside of the box ways we can address, human trafficking here in our state. So that baseline with the task force is to build better cases, support survivors. But part of the task force has allowed us to connect directly with resource agencies, survivor support agencies to support their need for funding, work with them on identifying and addressing gaps for need across the state. So that's a high level summary of the work at the Attorney General's office and the work that I'm focused on there. I would say until our work as prosecutors is no longer needed, we need to keep working on the ways we can do this better, right? So, the way we can, one of the ways we can do this better is when we're connected to those outside of the silo of our own organization and communicate effectively, right? So, so thank you all for being here and for being engaged. And it's so encouraging to see that so many of you are here today and hopefully motivated to get involved and to be engaged in anti-trafficking efforts.
Thank you so much for that, Beth. It's really refreshing to hear about the trauma-informed work and to also think about both using prosecution and also how the prosecutor's office is thinking outside of that for a more multidimensional approach to supporting survivors of trafficking. And our final panelist now, Cindy Reland, she has over 25 years of expertise litigating a wide variety of matters and has worked as lead or co-lead counsel in over 20 trials. She has been recognized on Law 360's first tier of top female trial attorneys, and she maintains an active pro bono practice, which includes representing human trafficking victims. Ms. Reland led the team that successfully defended pro bono client Lisa Aricchio in the first civil sex trafficking action brought under the Trafficking Victims Protection Act, the TVVA, against a hotel. The case garnered widespread media attention and established many critical precedents. under the TVPA, paving the way for similar cases to be filed by trafficking victims across the United States. Welcome, Cindy Freeland.
Thanks so much. It's so great to be a part of this conversation and to hear the insights of such an amazing collection of panelists. As Jasmine mentioned, my focus has been on the civil side. The federal TVPRA and the Massachusetts statute both include important civil remedy provisions that can be an important path both to obtain compensation for victims, and I think equally important to motivate people who are enabling trafficking, and in particular businesses, to do the right thing. There's been a lot of talk about the P of prevention. I think that the civil litigation can be a path to this as well. So just to highlight the law for starters, under the federal statute, a trafficking survivor, and I'll again use the word victim only because the statutes do. I know that my clients have for sure all been survivors. But under the federal statute, a trafficking victim can file a case against anyone that benefits from an association with a trafficker and that should have known of the trafficking. So it's an easier standard to meet than the criminal standard. The language of the federal statute is a little complicated, but just to throw it out there for starters, it says that a victim can bring a civil action against the direct trafficker, which the statute refers to as the perpetrator. And it says that a victim can also bring an action against anyone else who benefits financially or otherwise from participation in a venture which the person knew or should have known was involved in trafficking. It's a lot of complicated words, but the statute helps by confirming that the required venture is essentially any association in fact with a trafficker. So if you put it all together, it means that a victim can file a civil action against any entity or person that knowingly benefited from some association with the trafficker. So there has to be a knowing benefit, but they don't have to necessarily know about the trafficking. They just, the victim has to show that the defendant knew or should have known about the trafficking. As Jasmine mentioned, my colleagues and I had the opportunity to test the bounds of the federal statute in a case we filed a few years ago for an incredibly brave woman named Lisa Riccio. Lisa was brought to a motel in Seekonk, Massachusetts, and her trafficking started in the way that it happened so many times. He pretended to be her boyfriend, but in fact was a lifelong pimp. He brutalized her for 4 days and then told her he wanted to put her to work. He ultimately went to jail for his crimes based on the great work of the prosecutors involved in the case. And our case focused on the motel where these things happened because Lisa felt strongly that the couple managing the motel had played a big role in her ordeal. They saw what was happening to her and they ignored her pleas for help. When we filed the case, the district court initially dismissed it on the ground that we hadn't shown a knowing benefit to the motel of this trafficking under the civil statute. And it was incredibly disappointing at the time, but it ultimately turned out to be a good thing in the end. We appealed and we were able to get a terrific appeals decision from the First Circuit, authored by, of all people, Justice Souter, the retired Supreme Court Justice, reinstituting our case and making some important law. The First Circuit said that the payment of the room fee alone was enough of a knowing benefit for our case to go forward. We went back to the district court and received another terrific ruling from Justice Saylor here in Massachusetts, confirming that the lower negligence standard applies to these TVPRA claims. And we also had a little fight with an insurance company. He also confirmed that standard insurance terms can put insurers on hook for these types of claims. So in the end, we ultimately received much needed compensation for Lisa. She was amazing. She told her story to a captivated courtroom and 10 jurors. And the next morning, the settlement offered was substantially more than doubled. But I think what was meaningful to Lisa in the end was certainly to have some compensation to move on with. But also she was incredibly gratified to know that she'd made some important law along the way that would encourage further positive reforms by the hospitality industry. According to the Human Trafficking Legal Center that we work with, there have now been 59 more of these cases against hotels and motels. And for sure, there were responsible hotel and motels out there before our case that were doing the right thing and trying to shut down trafficking in their establishments. But there's been a whole lot more press about this since, and it's certainly been a focus. We hope, and I know Lisa hopes, towards that key of prevention. We've also seen bulletins by insurance companies warning their insureds about the dangers of turning a blind eye to trafficking. So this experience has definitely underscored to me that civil litigation can be a tool for sure for obtaining needed compensation, and that is certainly an important part of the statute, but also for motivating businesses to do the right thing for that key of prevention. And just to highlight a few of the areas where these civil cases are being filed, and it's definitely an area to creatively think about other ways to use these statutes. And I know we have a whole lot of creative thinkers participating today. As Alyssa from the prior panel highlighted, online solicitation is a huge problem. So this is definitely an important area. Craigslist back in the day used to have something it called adult services, the sort of pre-back page, and it shut it down following criticism that it was facilitating trafficking. When they shut it down, that was the reason they gave. Before being taken down by federal prosecutors for money laundering, Backpage also faced a civil TVPRA claim in Massachusetts. It ultimately was able to have that claim dismissed on the ground that it was a third-party service provider and was protected by the Computer Decency Act. So it was very disappointing to see that civil case not proceed, but very gratifying to see the creative federal prosecutors find other paths to bring down Backpage. But I'll note that Twitter, even after that Backpage case, Twitter just lost a motion to dismiss another TVPRA claim in California last year, based on an allegation that it hadn't taken down a video posted by a trafficker quickly enough. So this is definitely an important area for civil cases. We all, I'm sure, watched the Ghislaine Maxwell trial. That was a criminal case under the TVPRA, but enablers like her are certainly subject to civil liability as well. And the statute goes beyond monetary benefits. Any benefits that someone receives from an association with a trafficker when they should have known of the trafficking is subject to a civil case. Certainly, for example, the customers of traffickers would be subject to cases like this. And that is just the sex trafficking side of the potential civil cases. There's also a lot of important cases in the area of labor trafficking. We have so many labor trafficking issues that happen within our borders, but there's also been a lot of focus on trafficking in global supply chains, and a number of lawsuits against companies that sell goods in the United States that were produced by forced labor outside the United States. The 2008 amendments to the TVPRA actually included an express provision that gives courts jurisdiction over trafficking that happens outside the United States if the defendant is a US national or someone with US residence or a presence in the United States. And multiple courts have confirmed that this means that the TVPRA, and in contrast to some other federal statutes, does apply to conduct outside the United States. And there's some very interesting issues being hashed out in cases now. When you have a global supply chain with multiple entities in a chain, what kind of participation in that trafficking would a US company have to have in order to be held liable for the trafficking that happened somewhere else. There's a really interesting case working its way now through the California courts in a case against US companies selling goods produced by forced labor on fisheries in Thailand. It is a sad fact of Thailand and fisheries that studies show the majority, that at least half of them are the laborers are children in forced trafficking situations. So really important cases, and labor trafficking outside the United States, an important area of civil cases. Labor trafficking within the United States, an important area for civil cases. As prior panelists have commented, and I know that we'll have another panel this afternoon, the amount of labor trafficking that happens in our country is horrendous, and it's particularly happening to migrants without legal status who are too afraid to go to authorities and tell them what's happening. This is another important area for civil litigation. We've handled a number of domestic, of cases of people without litigation status just being abused and forced into servitude situations. And just one last comment before I close, it is, I know we have a lot of law students online today, and it's great to have as many people creatively thinking about ways to use these civil statutes as possible. Just last week, I spoke to a group of Northeastern students, law students there who are interested in thinking about whether the TVPRA might provide grounds for civil remedies for domestic abuse victims who are forced to work in a family business without being paid by a spouse. It's another really interesting potential application. And I got to tell you, I, for one, am going to be rooting for them. I would love to see the TVPRA be used that way as well. So in closing, I think the civil cases are by no means the whole package. The work that's being done at a policy level by people like Nicole and Ashley and in the state's attorney's office by Beth and the federal U.S. attorney's office is so important. But these civil cases can be part of the toolbox, that I think can also help with that key of prevention, as well as providing really needed remedies.
Wonderful. Thank you so much, Cindy, for really showing us how the civil litigation system can be used as well to try to support trafficking survivors. And so now I realize that I never introduced myself. I was so excited about the panel, but I'm Jasmine Gonzalez-Rose, and I'm a professor of law here at BU and also the Deputy Director of Research and Policy at the BU Center for Anti-Racist Research. And so we have some questions from our audience here. And so one question really focused first to Nicole, but open to others in thinking about how can impacted individuals, impacted communities get more involved in this sort of legislative efforts. And particularly, we have an audience member who's asked how minors who have been subject to human trafficking might have a voice in assisting these sort of policy efforts.
So I think that's a great question. So first and foremost, it's like an important balance of like, how do we ensure that we're centering the voices of those most impacted, but also while not exploiting or harming or putting people at risk, right? I will say, like Stephanie, you often see survivors coming forward publicly and not recognizing the impact that has long-term on their life. And so, part of how we ensured that, survivors and young people were involved in the legislative efforts is utilizing partners that serve them. And so, like, for example, like we worked with My Life, My Choice, and, their young people actually put together a presentation and went to I believe it was Attorney General's office on why they supported the equality model. The young people in our programming, put together, testimony and information and supported this legislation in writing testimony, right? So there's ways to involve young people without, you know, putting them in front of, you know, in a hearing or testifying in that way, right? And so it's really important that, you know, for us to ensure that we're capturing everybody's voices, not just the ones that are elevated for that people typically hear, you know. And so that's how we involve some of the young people in the legislative work that we did. So answers your question.
That's really helpful. Thank you so much for that response and that insight. I have a specific question here. I think that's really targeted towards Cindy. There's a question on what was the basis for civil damages in the case against the hotel owners? Was there a requirement to show some kind of monetary harm to the victimized individual, or does the statute permit some kind of punitive damages? Could you talk through that for us?
You know, and I have to say that the TVPRA is only, you know, one of, it's an important one of the statutes, but state tort law and, you know, other state laws can be part of it that also provide opportunities for punitive damages. But the basis for suing the motel was that they had a financial benefit from the receipt of a room fee. I mean, any benefit is enough. That was sort of our basis for filing the suit. But Lisa's recovery, the claim that she was able to make was for all of the harms that she had suffered. We worked with a terrific economist, accounting person from Stout, who was able to quantify both her financial harms and her emotional harms. So the amount of the room fee is really the way that you bring in the motel, but the victim is entitled to a full recovery of all lost wages, economic and emotional harms. And I hope that answered the question.
It did. Thank you so much. I have a question for really focused first for Beth, and also I'd like to hear Ashley weigh in on this. Beth, you talked about trauma-informed prosecution. I know there are a lot of law students in the audience and perhaps some young lawyers or aspiring lawyers. How can lawyers cultivate a trauma-informed approach in their professional development?
Sure, I think, you know, engaging in symposiums just like today to get themselves educated and in a place to have better understanding. You know, some of the ways that we talk about it with law enforcement is to just really recognize the prevalence of trauma, what that and how that impacts a person potentially in their ability to interact with law enforcement. But, you know, for law students, I would say the same, right? Thinking about, you know, clients or individuals they're encountering, like, you know, considering what is sort of behind that initial conversation or scenario you're involved in really takes a level of like thought, right, and investment in that consideration, right? And so, you know, with law enforcement, we talk about please do that first in your approach to a you know, individual and their scenario, and think about try to think about maybe what are the concerns immediately facing them, right? Safety, you know, safety, essential needs, and understanding the way that they may, you know, sort of respond to you may not comport with your idea of how they should or you know, what should happen, but there's a reason for that, right? So I think the same, you know, I would say the same when we're thinking in an approach to client-based as well as, again, I'm as a prosecutor speaking how I would be approaching law enforcement and a potential investigation, but that I think is universal, right? Just considering the individual in the instance and then sort of what brings them to the table, right? Allowing for that.
Yeah, I can jump into, and so yeah, from Dove's perspective at least, so you know, we're a direct services organization and I'm within the legal program. And so I would say Dove tries to really operate from an empowerment stance. And so within legal representation, that looks like making sure that we are believing clients when they call and acknowledging that they're the experts in their own lives. And so I think a lot of times there can be power imbalances that exist within a legal representation, expectations of just a lawyer making a casual comment and the implications that that can have to the client, maybe feeling like they're being told to do something. And so we really try to just present options, lay out, what is available to the clients that we're working with and encouraging them to make the choice that's best and safest for them. And so, yeah, I think coming from empowerment, coming from belief, and also just, having compassion on people's individual experiences and knowing that we may not always have understanding, but, if we can come in with a questioning attitude, that is going to be a way to foster hopefully a more positive experience for the client going through, within legal representations in this area, at least what are often really traumatic experiences.
Thank you. We only have 2 minutes left, so let me pose a two-part question here. One with generality. So, for instance, both Nicole and Ashley spoke about vacating records and so forth, and that is important work, basically removing these convictions and so forth. Some might look at that as these are harms that are directly caused by the system itself. So criminalizing the selling of sex, criminalizing status offenses. And so when we're focused on removing those, are we really focused on making the survivor whole? Or are we just focused on mitigating injuries directly caused by the system? So that's kind of a general question. And then also thinking about harms from the system, someone in the audience was asking about how has the TV PRA been implicated against law enforcement who have engaged in human trafficking or who have gained benefits from human trafficking. So maybe we can think a little bit systemically here, and I'd love to hear from anyone who has any reflections on those two questions.
So I want to start by saying yes, like fake should not need to exist because we should not be criminalizing victims, right? And so, again, as I talked about vacature and, Ashley, I appreciate you saying like there can be a power imbalance. There is a power imbalance, right? From somebody representing a survivor. There always is a power imbalance with law enforcement, and me and Beth have this conversation frequently when we talk about making law enforcement trauma informed. It is impossible to make law enforcement trauma informed. They are in a position of power always, right? They are making the choices, whether or not, so just to think about those things from a survivor's perspective, right? And, laying out choices like we often, as somebody who has been victimized over and over in my whole life, and I'm speaking for myself, but the reality is like, those wind up in prostitution. It's typically been a continuum of violence that they've experienced from childhood through adulthood, right? Often are making choices that we think you want us to make, right? Because we are trying to make others happy because we don't see any value in ourselves. That's a real thing that happens with survivors. And so we should not be criminalizing victims ever. And I think we need real reform in this area. We should not be asking in many other states. They actually are like asking for clemency. So they're asking for forgiveness for crimes that were committed against them, right? And so how do we shift so that we are not criminalizing prostituted people in prostitution anymore? Whether they are being trafficked or whether poverty is their trafficker, whether like inability to access employment is their trafficker, whether, right, like there are other drivers that lead people there, and they still should not be criminalized. So you're right, we are not making people whole. We are mitigating harm that the system has caused them. That is a factual statement.
Thank you so much for articulating that so clearly and so insightfully. Regretfully, we're at the end of our time, and I feel like these are conversations that could go on, and I hope that they do go on. We now have a break, but until 1:30 p.m. And at 1:30 p.m., we'll hear a keynote from Rachael Rollins, the U.S. Attorney for the District of Massachusetts, and I hope everyone can return and engage in that keynote. And please, thank you to all the panelists for these very, very thought-provoking presentations, and also thank you for the work that you're doing. It's truly impactful and very important, and it's been a joy to spend this past hour with you. Thank you.
Rachael S. Rollins is the United States Attorney for the District of Massachusetts. Nominated by President Joseph R. Biden on July 26, 2021, and confirmed by the United States Senate on December 8, 2021, Ms. Rollins is the Chief Federal Law Enforcement Officer for the District of Massachusetts and the first Black woman to hold the position. Prior to her confirmation, Ms. Rollins served as Suffolk County District Attorney for 3 years. She was the first woman to ever be elected DA in Suffolk County and the first woman of color to ever hold the position of DA in the Commonwealth of Massachusetts. Ms. Rollins previously served as Chief Legal Counsel to the Massachusetts Port Authority. Prior to that, she served as General Counsel for the Massachusetts Department of Transportation and the Massachusetts Bay Transportation Authority. From 2007 to 2011, she was an Assistant U.S. Attorney for the District of Massachusetts, serving in both the civil and criminal divisions. Earlier in her career, Ms. Rollins was an attorney at Bingham McCutcheon LLP. And from 1999 to 2002, she was a field attorney for the National Labor Relations Board. Ms. Rollins began her legal career as a clerk for Associate Judge Frederick L. Brown of the Massachusetts Appeals Court. Ms. Rollins earned her Juris Doctor from Northeastern University School of Law and Master's in Law from Georgetown University Law Center. She received a Bachelor of Arts degree in Education and African American Studies from the University of Massachusetts Amherst. And please join me in welcoming U.S. Attorney Rachael Rollins.
Thank you so much, Madison, for that kind introduction. I also want to thank the Public Interest Law Journal and the many sponsors of this event. I'm honored to be joining you today to speak about an issue that I have made one of my top priorities as U.S. Attorney, human trafficking. Some of you may have seen in the news recently that I, along with the Attorney General of the United States, Merrick Garland, announced the Department of Justice's strategy to combat human trafficking. Frankly, when I heard that the Department of Justice was bringing this issue to the forefront, I was incredibly appreciative because this has long been an important area of concern for me. As district attorney, I spent countless hours making sure that I made myself available to meet with victims, hired exceptional people like Liz Riley to make sure that we had the best prosecutors possible to focus on human trafficking and hold traffickers accountable as we could. We had programs like the Bravery Breakfast, where survivors of sexual assault and others of trafficking were commended and appreciated and shown support. As U.S. Attorney, I was fortunate to have walked into an office a month ago that over the last 15 years has prosecuted 40 cases involving allegations of sex or labor trafficking and prosecuted over 65 defendants. In fact, just yesterday, Bruce Brown, a notorious longtime trafficker of women in Boston and throughout Massachusetts, was sentenced to 12 years in federal prison for trafficking 4 victims, including a minor. While the U.S. Attorney's Office has done good work, under my leadership as the new U.S. Attorney, I plan on significantly expanding our efforts with human trafficking, increasing resources to manage more cases, and assisting as many victims and survivors as possible. The truth is that our statistics tell only part of the story. The U.S. Attorney's Office has worked with over 100 people who were trafficked, harmed, and taken advantage of. We have assisted them with challenges ranging from medical and mental health care, substance use treatment, housing, education, parenting issues, and jobs. We know that we cannot make these important cases without their cooperation and assistance. I think we all understand the toll, the significant toll that these cases take on the individuals that are trafficked and their families. And we recognize the long path that they may face in reclaiming their lives. For example, one of the victims of Bruce Brown, the man who I mentioned was sentenced yesterday, tragically died of an overdose while the case was pending. She wasn't able to be there to confront the person that harmed her, used her, and exploited her. The trauma she endured at the hands of that now convicted man likely played into her pain and possibly into her substance use as well. It's our job as prosecutors to speak for her and communicate to the court her perseverance and strength. All of these victims are remarkable, as is their ability to overcome unimaginable harm, deception, and the stigmatization that comes with the trauma they endured. And we need to start speaking about and stigmatizing the trafficker, not the trafficked. These survivors reaffirm the importance of this work and the projects like today's symposium. So I want to speak with you very briefly about how the U.S. Attorney's Office prosecutes human trafficking cases, because the way we do these cases is just as important as why we do them. I hope it is not a secret that I believe in a victim and survivor-centered approach in all cases, but particularly in human trafficking cases. From the line prosecutors to the victim witness specialists to the agents or police officers that are involved in these cases, we follow a victim-centered, trauma-informed, culturally sensitive approach. These aren't just words that we use. This approach defines how we do our work. I am so committed to this approach that I put it in writing. In 2019, right after I became the elected district attorney of Suffolk County, my office, the DA's office, proposed a memorandum of understanding in support of a coordinated, multidisciplinary approach to commercial sex exploitation of children and the trafficking of children in Suffolk County. That MOU, Memorandum of Understanding, codified a victim-centered approach and prescribed best practices for prosecutors, law enforcement, child advocates, and Massachusetts Department of Children and Families, mental health and youth services, Massachusetts probation, as well as youth services providers and medical providers. It also included federal law enforcement partners such as the FBI and HSI, which stands for Homeland Security Investigations, which is the largest investigative arm of the Department of Homeland Security. We worked incredibly closely also with the Boston Police Department, who does exceptional work in this space as well. While that document, that MOU, covered youth exploitation in Suffolk County, fortunately, as U.S. Attorney, I plan on following the same practice in all trafficking cases, not just in Suffolk County, but in the entire Commonwealth of Massachusetts. And we are already doing that. So what does that really mean? First of all, I think it's important that you understand it starts at the top. My assistant United States attorneys and victim witness specialists know that I will literally drop anything I am doing to meet with a victim. If I am in a meeting, if I am on the phone with the Department of Justice, if I am meeting with a judge and I am told that there is a victim in the building, like I did as DA, I will stop what I am doing to make sure that if they are interested, meet with them. As I said, it's something I did as DA and something I will continue to do as US Attorney. I want victims and survivors to know that they matter and that we acknowledge their trauma and the harm that they have endured at the highest levels, and that we intend to do right by them. In addition to telling them that, I actually also shut up and listen and give them an opportunity, if they are comfortable, to tell me as the elected district attorney or the US attorney, the highest federal prosecutor in our Commonwealth, what they want me to hear about their experiences in the criminal legal system while they were being harmed, or any touch that they've had with the system that I'm involved with. Next, my office has trained the attorneys and victim witness staff in important things like empathy and compassion and interviewing, and not re-traumatizing people with the questioning that they propose. When I talk about empathy, it's really important that you understand that although I do love my current staff at the US Attorney's Office, federal prosecutors are a little different than state prosecutors. State prosecutors are usually on the ground, involved in things the minute that they happen, as well as local law enforcement. So as DA of Suffolk County, the Boston police, detectives, excellent people working in this, would be dealing with victims and survivors immediately. My ADAs and my victim witness advocates would be involved immediately on day one. Sometimes at the federal level, we don't get involved until a little bit after. And there have been allegations that as federal prosecutors, we can be a little aloof and not as involved as maybe those local prosecutors, those on the ground detectives and others. I have really focused, joking aside, on making sure that the exceptionally hardworking and smart people that work in the US Attorney's Office also have empathy and compassion, are culturally competent, and are capable of meeting with and listening to survivors and assisting them on their path toward accountability for the individuals that targeted them. Additionally, we've done training on interviewing techniques, as I said, so we don't re-traumatize survivors, while at the same time making sure we learn all the necessary facts so we can hold traffickers accountable. Lastly, but certainly not least, our victim witness specialists work with victims and survivors from the start of the investigation in conjunction with our law enforcement partners. We want victims and survivors to understand that they can reach out at any time for help, and we will do whatever we can to get them assistance. So for example, just last week at the US Attorney's Office, my staff worked with a survivor from a case that was charged in 2015. She is now doing exceptionally well, but had some safety concerns and housing issues. So right now, my office is working to connect her to the right people. We are committed to helping her even over a decade after the case and the charge was brought. One reality that we deal with is that federal prosecutors' offices are not set up, as I said earlier, to provide direct services to survivors. We don't provide the treatment ourselves. We often need to get creative and partner with our local and state counterparts to assist, but that does not hinder our commitment to helping a victim or survivor. I want to be clear, part of why I'm so proud of the work I did as DA, as an elected district attorney, and now as the appointed, presidentially appointed and Senate confirmed US attorney, is I have all of those connections, certainly in Suffolk County, with all of those local law enforcement partners, community organizations and partners, like My Life, My Choice, as well as joint task forces that have been deeply involved in these type of cases. And if it is outside of Suffolk County, as a former elected DA, I am very well aware of all of the exceptional district attorneys around the Commonwealth and can reach out to them for their contacts in their counties. Because the partnerships and service providers and community organizations are critical in our ability to ensure that survivors get the help that they need. We understand that a victim-centered approach means working closely with them, and we pledge to do so. So while I'm sure that you know that as prosecutors, we are on the right path, we also recognize that there's a lot more we need to do to fight against human trafficking. 2 weeks ago, the Department of Justice issued a national strategy to combat human trafficking. Central to that strategy were the 3 Ps, or are the 3 Ps: protection of victims of trafficking, prosecution of human traffickers, and prevention of human trafficking. So protection of the victims, prosecution of the traffickers, and prevention of trafficking. My office has already adopted many of the best practices advocated by the department, and as a result, Massachusetts is at the forefront of the fight against trafficking. But as we know, even one trafficked individual is too many. So our work continues. My prosecutors are covering one of the 3 Ps. We are prosecuting the traffickers, but we really, really need you and our law enforcement partners, community partners, as well as individuals at this symposium to help us with the other 2 Ps. So I want to thank you for an opportunity to speak with you. I want to make sure that we give, I give a shout out, as I said already, to Assistant District Attorney Liz Riley, who I worked very closely with, Assistant District Attorney Luke Goldworm, who oversees the Human Trafficking Unit at the Suffolk County DA's office, Tim Moran, who is the Assistant United States Attorney who handles many of these cases at the U.S. Attorney's Office, our victim witness advocates in the Suffolk County DA's office run by Charlene Luma, as well as our victim witness advocates at the U.S. Attorney's Office, Kathleen Griffin, and our law enforcement partners. I've had many, many conversations with Detective Sullivan of the Boston Police Department, who's on a task force, as well as federal partners who are deeply, deeply, deeply committed to this work. So I appreciate you letting me speak. I am excited about the work that we are going to do, and I am optimistic about targeting traffickers and making sure that we end this exploitation. Thank you.
Thank you so much, Attorney Rollins, for sharing these wise words and experiences with us. We're honestly so honored that you could join us here today. We will now take a short break until 2 o'clock when we convene our next panel on immigration and trafficking.
And I am a clinical associate professor at BU School of Law and also the director of the BU Law Immigrants' Rights and Human Trafficking Program. I want to join the other panelists to thank the Public Interest Law Journal for hosting this important symposium. And I'm really just thrilled to be here and moderate this next panel, which focuses on intersections between immigration and human trafficking. We have such an amazing group of panelists, leading scholars, attorneys, and a talented sociologist and colleague who really have the ability to engage around these intersections from various different perspectives. As has already been mentioned, trafficking can impact both individuals who are citizens and non-citizens alike. However, several factors make cases of non-citizens unique. Often their precarious immigration status, vulnerability to deportation, and pervasive fears about engagement with the state, whether that be the criminal legal system, accessing benefits, or child welfare systems. And while Congress established a unique protection for immigrant survivors, which you've heard about throughout the day, the T visa, some have observed, and some in this panel will also observe, that it has been tragically underutilized. Despite 5,000 available annually, relatively fewer granted each year, with denial rates that especially grew during the last Trump administration. And applications may now take more than 2 years for a decision, leaving survivors in precarious limbo for a very long time. While there are short-term protections, some will talk today about continued presence, a short-term form of deferred action, which Congress tried to use to fill this gap and provide work card access for non-citizen survivors earlier in the process, even this protection remains challenging to access, requiring engagement with law enforcement, and also can be very discretionary. So our esteemed panelists are going to talk about these challenges within the TVisa context and also beyond, engaging with broader questions about immigration law and enforcement, and thinking about how we can creatively reimagine new possibilities. So before we jump into the panel, I just want to make a couple of notes about logistics. I'm going to briefly share the bios of each speaker before they do speak. They're somewhat abridged because I want you to hear from them and have more time to hear from them. Each panelist will talk for about 10 minutes, and then we're going to hold time at the end for Q&A. So please, if you have questions throughout the panels, please enter them in the Q&A, and we hopefully will have 10 to 20 minutes at the end to respond. So with that, I'm going to introduce our first panelist, Kathleen Kim. Professor Kim is a professor of law at Loyola Law School, Los Angeles. She's also the co-author of Human Trafficking Law and Policy, the leading casebook on human trafficking in the country, and the faculty advisor to the Loyola Immigrant Justice Clinic, which she helped to co-found with her students. With that, I'll turn it over to Professor Kim.
Thank you, Professor Dahlstrom. Thanks to Boston University School of Law and its Public Interest Law Journal for hosting this conference, which was really thoughtfully put together. Thank you for the invitation to participate. I'm happy to open this panel with perspectives on the intersection of immigration and human trafficking, and I thought I would provide the historical backdrop for what is an inextricable connection with immigration and human trafficking. And so just with one comment about our contemporary circumstances, and then I'll move to the historical background. It's probably no other time in our lifetimes where we've observed, in particular with such access to information, video, media, the harmful consequences of draconian immigration policies and enforcement at the border and in the interior. And perhaps for the first time, we've been able to see in such vivid detail the outcomes such as human trafficking that derive from methods of enforcement that cause individuals or migrants to have to resort to unsafe means of coming into the United States, which necessarily makes them vulnerable and subjects them to enforcement measures that from the very beginning of our history of immigration laws have been intended to exclude and or remove non-citizens who are among the most precarious among us. So, so with that in mind, I wanted to quote James Baldwin about the significance of history, and if you just give me a moment. So James Baldwin, from his piece, The Price of the Ticket, collected nonfiction, he says, quote, "The great force of history comes from the fact that we carry it within us, are unconsciously controlled by it in many ways, and history is literally present in all we do," end quote. So with immigration and in consideration of human trafficking, history, from my perspective, does tell us a lot. I wouldn't say that history repeats itself in a uniform and methodical way, but history as manifested in the United States certainly shows us how structural power has been entrenched and how legal regimes appear to persistently reify categories of populations that remain more targeted by government enforcement forces than others. And it so happens that those categories of government enforcement also remain the most vulnerable to exploitation and mistreatment, including those victimized by human trafficking. I'm going to attempt to share a slide. Okay, great. So and this might be a little bit too far back historically, but I'm going to zip through this pretty quickly. So many of us know that the United States began with colonialist efforts, which it's a long and complicated history, but which in part decimated much of the native population that existed in the United States. And the first migrant influx occurred when California became a part of the United States right after the US-Mexico War. And immediately after that, in 1849, gold was discovered, and which caused the gold rush. And gold rush was relatively unregulated, and there was a great westward expansion from Americans on the east, but also international prospectors, including a good number of international prospectors from China, other parts in Asia, and also Russia. So a settlement of a Chinese population began in the United States and also started to grow. Interestingly, soon after the gold rush, fugitive slave acts were passed, and that was the first federal statute to exercise federal power to enforce criminal laws against victims of chattel slavery who had escaped from their owners, and empowered law enforcement to quote unquote capture those fugitive slaves and have them returned to their owners. And this was an exercise of federal power that had not occurred before. And that exercise of federal power foregrounds a growing, expansive federal government, federal presence across the United States, a still pretty new collection of states that had regulated themselves for the most part. The Civil War, we might have learned when we were in grade school or middle school or even high school that it was a war about federal power versus the states, which is in part true, but an important piece of that, and perhaps the most important piece of that, is that the issue being fought over by the federal government or the northern states and the southern states was the legality of chattel slavery. The Civil War was won by the federal government, and Lincoln, in a contested battle over his election to the presidency, prevailed in abolishing chattel slavery, both through the win over the Civil War and also through the ratification of the 13th Amendment, which enacted the Emancipation Proclamation. So 1865, the formerly formerly enslaved Africans and descendants of Africans became free, and 4 million newly freed slaves became members of the United States. Soon after that, the 14th and 15th Amendments were passed. So the two other Reconstruction amendments. And this all happened within a short amount of time, the first 5 years of Reconstruction. And then there are 4 million new voting members, United States citizens who could vote in elections. And during Reconstruction, Black representatives reached 15% of the legislature, state and federal, and that proportion has never been reached again. Interestingly, this is at the same time that Reconstruction was being enforced by federal troops in the southern states. Part of the impetus for that was because southern states had started to enact their own criminal laws meant to re-enslave newly freed slaves, like black codes, which subjected them to criminal penalty if they were loitering or vagrant, which in essence forced them into debt servitude contracts with employers who had previously been their slave owners and plantation owners. And the force of law via criminal penalty was utilized to coerce workers into debt servitude contracts and peonage contracts, which later became another violation of the 13th Amendment. Chinese workers continued to enter the United States during this time of Reconstruction to fill a gap in labor needs, labor shortages that had been created by the 13th Amendment. And this is also when our first federal immigration exclusion acts were passed. So our first immigration laws, federal immigration laws, were ones that were focused on enforcement and meant to reduce and eliminate the growing numbers of migrant workers of color, also from south of the border, Mexican workers, both called coolies, Chinese coolies and Mexican coolies, because they, which was the colloquialism for indentured workers at the time. The PILJ Act of 1875 is notable as the first act to have excluded not only Chinese men who appear to be either criminals or coolies, but also Chinese and other Oriental women who were perceived to be prostitutes. And the language of the act was very explicit as to its gendered and racist underpinnings. And I think we can see through our immigration law history the very direct connection between how our society, the United States, perceives categories and populations today, and how they were overtly constructed by laws during the time of Reconstruction. So the racial caste system that had been entrenched through the practice of antebellum chattel slavery persisted in the way that new groups of vulnerable, disposable workers were also raced and gendered. Our immigration laws continued to codify those race and gender categories through a series of Chinese exclusion acts, and then certainly through the Bracero program, and I'm moving into Jim Crow era segregation, separate but equal, as the Supreme Court decided in Plessy versus Ferguson. And throughout these decades of Jim Crow segregation, our immigration laws continued to be racially exclusionary, vastly either preventing or drastically limiting the numbers of immigrants of color, particularly from any country outside of Europe. And that was only repealed once we get to the civil rights era, the 1960s, and the 1965 Immigration Nationality Act at the height of the civil rights movement was enacted to overhaul our immigration system and to repeal the racially exclusionary immigration laws that had accumulated up until that date. Still, we see pockets of, well, not just pockets, but we see persistence of same kinds of racial exclusionary measures that manifest in immigration laws, despite the Immigration Nationality Act. And some might say that it has to do with the enormous concentration of power put in the political branches of our federal government to enforce immigration laws and to enact immigration policies without constitutional judicial review. Human trafficking has been one area that there are both immigration benefits, but also an area that can often be used as pretext for immigration enforcement actions by Immigration Customs Enforcement or Customs and Border Patrol, often leading to perhaps the wrongful removal and detention of through the collateral consequences of these immigration enforcement actions of a vast population of undocumented workers who are otherwise law-abiding. And with that, I'm going to pass it on. I'm sorry to have taken up more time than permitted. Thank you. I welcome discussion at the end.
Thank you, Professor Kim. Thank you also for that historical context in the sense of, you know, these interventions aimed at trafficking early on were not only racialized, gendered, but also very much enforcement actions and remain so now. And so I'm sure other panelists will engage around these topics as well. So we're going to actually go from the historical context to the modern context and invite Stephanie Richard, who is our next panelist. Stephanie is the director of the law school's Rights in Systems Enforced or RISE clinic at Loyola Law School in Los Angeles, California. And prior to joining Loyola, Richard served as the Policy and Legal Services Director at the Coalition to Abolish Slavery and Trafficking, and comes with an immense amount of both policy and direct legal experience. So with that, I'm really excited to welcome Stephanie. Professor Richard.
Thank you. I'm really excited to be here and always happy to follow Professor Kim. We've worked together for over 20 years on anti-trafficking work, and I think Julie, you and I might have worked for the same time period. So Kathleen Kim gave you kind of a historical perspective on anti-trafficking immigration policy and some of the barriers. And I just wanted today to speak on two kind of current issues that we see that I think, you know, show the difficulty in truly looking at preventing human trafficking before it starts, and even just survivors still accessing basic benefits. So gosh, almost 10 years ago, I worked with a national coalition of experts on human trafficking, and we really talked about, well, what would be a policy platform that could help prevent trafficking before it started, with the understanding that we knew that prosecution was not prevention, and that these complex, vulnerable communities needed complex, diverse solutions. In the immigration context, one of the issues that national experts agreed on at the time was looking at the issue of foreign labor recruitment. And that was because those of us who are service providers directly serving clients here in the United States, we're identifying that almost 2/3 of the immigrant survivors we were serving came to the US on temporary visas. So our temporary immigration system is one that's very complex. There's over 20 different visa categories, but one of the things that makes them very easy for exploitation is that they're linked to an employer and they're time limited. And what we saw in with our anti-trafficking work is that one of the ways that workers coming to the US on these visas were being kind of exploited and or ensnared in a trafficking stream was happening at the point of recruitment, because foreign labor recruiters were operating with false promises and then charging the worker a fee for the temporary visa, even though the employer was being charged. So it was like double dipping. So what you had was trafficking survivors coming to the US with these enormous debts, anywhere from $1,000 to $25,000 in my experience, and knowing that a worker, even a debt of $1,000 to $2,000 or $3,000 can be insurmountable of making that back in their home country. And then we also saw immigrant survivors paying for these exorbitant fees by taking out money from loan sharks, from going into debt with that foreign labor recruiter, mortgaging family property, or just borrowing money from everyone they knew. So what it did is create these circumstances that made them even more vulnerable to exploitation and human trafficking once they arrived in the US. And so, you know, a better federal system regulating foreign labor recruiters was something that, as I said, we identified based on research and service provider experience as something that would work. And we actually had, in 2013, a draft provision of that bill attached the last comprehensive immigration reform that moved, which, gosh, it's been so long, in the Senate. And then we even convinced the Republican chair of the Foreign Affairs Committee, Chairman Royce at the time from California, to introduce almost the same exact version of the bill as a standalone bill. And it was then that our efforts were seen as likely to succeed, and the business community got involved, namely the chamber, who met with us, a group of advocates, and I was a very young advocate at the time, and I still think it was one of the most interesting and unusual meetings I've ever been part of in policy. And literally, their lobbyist pounded his hand on the table and said, "We will not negotiate, we will defeat you." And, you know, we didn't know what that meant, but what it meant was the next day, Republican leadership had Chairman Royce got the foreign labor bill that we had put forward, and we had to remove our support from that legislation. And that bill, you know, still has not been reintroduced or brought forward again. And there is hope that in the next cycle of the Trafficking Victims Protection Act, we might see those provisions, but it just goes to the depth of difficulties and truly transforming and taking preventive work in this complex issue. Because as we know, this is just one small change that we needed to make to assist just the temporary workers, right, coming on lawful visas to the US from being exploited. But true, right, trafficking prevention policy would be revamping our whole immigration system, which we as experts, you know, 10 years ago assessed probably wasn't possible. And so, you know, even found this small piece to be difficult. And then the last thing I just want to speak about, and I know I don't have that much time, is just, you know, looking again at the T visa, which Julie mentioned at the beginning, which is the specialized form of relief for trafficking victims. it is extremely difficult to get. The 5,000 visas that are available, I think the most that's ever been granted is just over 1,000 a year. So there's plenty available for trafficking survivors. And we know that the trafficking survivors in the US are far higher than the visa category allows. Gosh, since the Trafficking Victims Protection Act was passed in 2000 that created the T visa, advocates like myself, and this started with the Freedom Network USA, have advocated in every single reauthorization. So that started in 2003 and it's reauthorized every 3 years to remove one of the standards from the T visa as unnecessary, as well as creating a higher burden for trafficking victims. So the 4 elements of the T visa are that you have to be a victim of severe form of trafficking, you have to be in the US on account of the trafficking, and that if you went back, you'd suffer unusual harm, and that there had to be cooperation with law enforcement with some exceptions. And so the standard that we felt like could be removed was this on account of standard. And again, our advocacy efforts have never succeeded in lowering the standard, even though everyone recognizes that T visas are not granted. And then what we saw under the Trump administration was that this standard, the on account of standard, was even utilized against trafficking victims. So trafficking victims who took a long time to apply or remained in the US without like significant reasons were being denied at a much higher rate. I also want to say that my own opinion, and I have wanted to litigate this issue for years, is that the on account of standard has also been inappropriately interpreted given the statutory language in the actual implementing regulations for the T visas. I believe that on its face, the standard says that you just have to be in the US on account of trafficking, but how the US government has interpreted it is that you have to have remained in the US after your trafficking, so you can't really have left except for a few exceptions, and anyone fleeing trafficking in, say, a different country, right, is not eligible for the trafficking because they don't see it being in the US after your trafficking, having fled it, as a reason. So your trafficking has to have happened in the US. So these are the kind of changes that, if we made them, would substantially increase the numbers of individuals eligible for the T visa, but also even for those trafficking victims who squarely fall under that definition, avoid barriers under different administrations' interpretation. So I will stop there and look forward to all your questions in the future.
Thank you, Professor Richard, both for the broader context and talking about, how with their unique challenges that give rise to trafficking, and we need these tailored solutions, but some of the challenges in enacting those changes, and also that very textured analysis of the T visa and some of the challenges that survivors may have in accessing protection, and how it has been interpreted to be a very, in some ways, limited form of relief. And this, in some ways, leads us nicely to our next presenter. I'm really excited to introduce Heba Goaid, who is the Mormon Simon Assistant Professor of Sociology at Boston University. She is a colleague, and we've had the pleasure of working together on this project. Her research, which is global and comparative, examines how low-income people traverse social services, immigration laws, and their associated bureaucracies while grappling with gender and racial inequalities. So you can see that she might be well positioned to examine some of those issues in this context. And we should congratulate her. Her book, Refuge, is forthcoming with Princeton University Press, and I hear that she may have received a copy of it today. So with that, I will turn it over to Heba.
Thank you so much, Julie, for that generous introduction. And I have a disclaimer before I begin. So I have had the pleasure of co-authoring on this project with Julie Dahlstrom. Julie, can you all see my slide okay?
Yes, we can see it.
Okay, great. I have had the pleasure of collaborating with Julie Dahlstrom. I am not myself a lawyer, so any mistakes I make on that side, please blame me and not Julie. And I'm so glad she's here to also answer some questions that you all might have that I might not be equipped to answer. So today I'm going to share with you briefly some of the findings of a project that Julie and I are working on together that's called Securing a T Visa and Exploration of Inequality and Trafficking Protection. And the central question that we have is, or that motivates our research, is how do survivors and their legal advocates experience the Trafficking Victims Protection Act, the TVPA, and how it can be better reformed to protect survivors. And as you all know, the International Labor Organization estimates that over 25 million people, disproportionately from the global South, are victims of human trafficking. And in the United States, human trafficking law has evolved to address survivors. However, sitting in a scaffold of, as we heard from the other panelists, racist and exclusionary immigration system, exploitative labor laws, and a punitive criminal legal system, it often fails to provide the protection it promises. So through a collaboration across our disciplinary lines, our project sort of investigates how that protection works. And we recognize that the experiences of people who are seeking out this protection may have changed over time. And what we're going to provide today is sort of a more recent snapshot from our research. So as you all know, as you just heard from the other panelists, TVs is a special form of relief for immigrant survivors of human trafficking. And fewer than 1,100 applicants are granted T1 visas each year. And we're looking here at principal T1 applicants, not family members. Denial rates have ballooned, with almost 50% denied in 2020. And as we learned, inequalities of race, gender, and legal status tend to shape access to this protection. And particularly, you could think about this on different levels, like micro level factors as to who can access which lawyer and at what cost, meso level factors such as education and awareness about trafficking, and then more macro level factors such as what kinds of immigration relief are available to people. And here's a graphic pulled from USCIS that just shows the denial rate. And this is, of course, percent of denied cases out of the total cases adjudicated per fiscal year. We also know that, and I think Julie pulled this yesterday, we know that processing times are still very, very long. And this is really discrepant with what early T visas, what advocates say that early T visas took, which was only about 6 months. So what we set out to do is really do a qualitative exploration of sort of what are the obstacles to advocacy and what are the obstacles to this kind of protection. So we did a project that was comprised of 3 different parts. The first was a survey with lawyers, practitioners, and we did the data collection on this, but we're still kind of analyzing it. And these are lawyers who work on T visa applications. We got about 221 responses. We also we sought out this group through collaboration with leading human trafficking and advocacy organizations. And through the survey, we identified 40 lawyers to do in-depth interviews with, and we have completed those, but again, are sort of in that analysis process. And last, we're currently submitting our IRB to interview immigrant survivors, which we hope to conduct later in the spring to ask them about what kinds of obstacles they face in applying for T visa protection. And so to start off, let me share with you a snapshot. Again, this is early preliminary findings, but let me share with you a snapshot of what we found with the survey. So we found that changing administrative policies resulted in elongated application processes characterized by bureaucratic burdens. This occurred in a few different ways. So as you all know, there are 3 possible outcomes for T visa applications. It can be returned or rejected. There can be a request for additional evidence, or the application can be denied outright, in which case it would usually go through an appeals process. We also saw that processing delays had increased. And so we asked lawyers to speak about their experience with these in the 4 years prior to the survey, which corresponded with the Trump administration. And upticks in all 3 issues in terms of returns or rejections, requests for evidence, and denials were reported. So 35% of the respondents reported an application returned or rejected for a defect in filing. And these increases are likely due to policies about the content of the forms, including how the agency adjudicates fee waivers. And some even reported that they were rejected for failing to fill out a field. We also found that almost 4 in 5 had requests for additional evidence for filed applications regarding the T visa or associated inadmissibility waiver application, and those were super common. The majority of these were either on account of a failure to show that the applicant was in the United States because of trafficking, as we just heard from the previous panelists, which is a requirement for the T visa, or a failure to show that the applicant is a victim of a severe form of human trafficking. And this tracks with other reports by advocates of a new de facto filing deadlines that immigration was applying related to on the account of deadline. While there is no filing deadline, while there is no deadline for filing a T visa under the Trump administration, actors were deciding T visa applications and interpreting it to mean that the trafficking had to be reported in or T visa filed within years of trafficking, even though the law had no such requirement. So these requests for evidence, while not denials, of course, elongated the application process, leaving survivors in precarious positions in the interim. Finally, there was also a reported increase in denials at around 70%. And of course, denials expose an applicant to immigration proceedings known as removal or deportation proceedings, which is a policy that was enacted in June 2019 under the Trump administration. And the policy of denials was particularly jarring, not only because it exposed survivors to deportation, but also because denials under the Trump administration increased markedly according to national data. Though T visa requirements themselves hadn't changed, the number of denials continued to rise. And the denials lawyers told us were based on harsh, unfair, and unrealistic interpretations of the TVPA. Denials came on account of a failure to show that a survivor was in the United States on account of trafficking or that they were victims of severe forms of trafficking. So we're noticing a theme here. Finally, and then second, we did some in-depth interviews with a subset of lawyers. And this is really in sort of, we're in the preliminary analysis. We have a team of students coding that data. But the lawyers express how difficult it is to advocate for their clients in this environment, and the challenges of navigating government agencies, including law enforcement and the USCIS, in order to secure support for their clients. They spoke about strategies for filing and experiences they had where clients they saw as eligible were denied or processes took years to come to fruition. And another underlying concern was also whether nationally lawyers had full knowledge on how to advocate for clients around T visas. Lawyers in this process become gatekeepers, and some raise questions about how they define trafficking and how this impacted who and how they advocated for survivors. And a repeated refrain was a concern that survivors didn't have access to advocacy or to proper advocacy. As one lawyer put it, what is the situation for people who don't have any advocacy, and how many of those cases are happening with us not even knowing them? And then finally, we're hoping to do interviews with survivors, and we would really love if anybody in the audience or if anybody on the panel has some advice or thoughts on how to do that work. So we're currently in the process of recruiting and also filling out the IRB in order to do that recruitment. So finally, before I log off and allow the next panelists to go ahead, I wanted to sort of bring three concluding thoughts. So first, this project is only possible due to an interdisciplinary approach. I certainly would not have known anything about T visas or the intricacies of the law without collaborating with Julie. And sociological methods bring a unique sort of perspective on how to ask questions of the social world. So, bridging those boundaries has helped us sort of do this project and think about these issues together from a socio-legal standpoint. And we're still in the early stages and very excited to share our findings after the summer when we complete further interviews, which we hope to address both sociological and legal audiences. Second, we've really had to think carefully, and we continue to think carefully as we embark on this last stage of the project, in particular in terms of research ethics. So I'm happy to talk about this more in the Q&A, but we've been thinking about trauma-informed interviewing approaches and how to make sure in the process of recruitment and interviewing that we are as ethical as possible, something that's not necessarily covered by internal review boards that govern our research. So with that, I'm going to stop talking, and I look forward to the Q&A.
Thanks so much, Heba, for sharing those findings, and also just for the opportunity, I think, highlighting the importance of interdisciplinary work and some of the unique challenges that arise in that context. So hopefully we'll have more time to engage in Q&A in just a moment. So with that, we're going to move sort of from this kind of deep dive into the T visa to some broader concerns about trafficking survivors in detention and some of the challenges they face in terms of both identification and accessing those protections. So I'm delighted to introduce Arifa Raza, who is an assistant professor in the Department of Criminal Justice and Criminology at Washington State University. Dr. Raza's current research examines the criminalization and racialization of immigrants through immigration laws, focusing on humanitarian relief for victims of trafficking and immigrant children. So welcome, Arifa, Professor Raza, and thank you for joining us.
Hi, thank you for having me. Let me see am I sharing my screen? Let's see.
Yes, we can see your
Yeah, you're perfect. Okay, let's see. Slideshow. Can you still see it as the slideshow? Yes. Perfect. All right. Well, thank you so much for having me, and thank you for putting me on such an amazing panel with some renowned experts and people I've looked up to for a long time. So hi, everyone. My name is Arifa, and I'll be talking about some of the few challenges detained victims of trafficking face within the context of immigrant detention. So I'll provide like a 1-minute overview of the immigrant detention system, and then talk about some of the challenges that migrants who are trafficked face in obtaining protections under the T visa. And so while it's not specific to detained migrants, it's helpful to understand the multiple victimizations faced by migrants who are detained. So that'll lead us to our last part, which is a discussion of forced labor within privately owned and operated detention centers. And when thinking about potential recommendations, I'm hoping to push that to the Q&A if time permits. So, in 1 minute, what's the immigrant detention system? It's this complex web comprised of federal, state, local agencies, and private corporations. As of 2019, there were over 200 facilities used to hold immigrants. The majority of those are owned and operated by private prison corporations. So typically immigrants are apprehended by immigration authorities, either internally within the United States or at a port of entry or between official ports of entries. So when a migrant presents at a port of entry and expresses or apprehended in between a port of entry, and they express a fear of return to their country, CBP is required to initiate the process for a credible fear interview. And that's really important because the credible fear interview is that first stage when someone is claiming asylum, and that starts that asylum process. So usually CBP then transfers the asylum seeker to ICE custody, and if they pass a credible fear interview, then they're placed in removal proceedings before an immigration judge where they fight their deportation and they fight their asylum claims. So unless otherwise subject to mandatory detention, DHS, or the Department of Homeland Security, has the discretion to release a detained person during their removal proceedings. But they don't generally do that. The US generally holds around 45,000 people in immigrant detention daily, but there was a time when it averaged above 50,000. But because of the pandemic, that has dropped significantly to about 20,000, which is where we're at currently. And as a reminder, the immigrant detention system is a civil system. It's not a criminal system. And the whole purpose of detaining migrants and immigrants is ostensibly to ensure their court appearances and to effect their removal. So it's not intended to serve any punitive purpose. So that was my 2-minute overview of the immigrant detention system. So I wanted to center our conversation today around a case that I think really exemplifies the multiple challenges migrant victims of trafficking face in the context of detention. So there's this case, Gonzalez v. CoreCivic. It's a civil lawsuit against the actions of CoreCivic, which is one of the largest private prison corporations, which we'll talk about in the next part. But just to give some background of the lead plaintiff, Ms. Gonzalez was a victim of domestic violence in her home country. She decided to flee her home country and seek asylum in the United States. So in order to come to the United States, she secured the services of a smuggler. In the process of being smuggled, she is threatened with violence and forced to submit to commercial sex by her smugglers, or more appropriately, by her traffickers. So Ms. Gonzalez was able to escape her traffickers and then contact immigration authorities, or make contact with immigration authorities. However, she's then placed in detention. So she's sent to various detention centers throughout Texas. And during that time, she's fighting her immigration case in detention. Based on her trafficking, she applies for a T visa, which is granted. And only once it's granted is her immigration court case completed, and she's finally released from the detention center. So in all, Ms. Gonzalez is detained for a little over a year. And so A few things to highlight is that her case shows the precarious position those fleeing violence and persecution face when migrating to the US. In her case, she's fleeing violence and she's trafficked in the process of seeking refuge. She's then detained. However, her immigration or her migration story is not unique. Various studies have established that asylum seekers and other migrants face tremendous risk during their journey to safety, including being trafficked. And then many times what starts out as smuggling quickly turns into a trafficking situation, such as the case with Ms. Gonzalez. However, what's different in her case is arguably the fact that she was able to obtain a T visa for the trafficking that occurred. For many asylum seekers that are trafficked on their journey to the US, they cannot secure a T visa. And so Professor Richards mentioned that, and she was talking about the on account of standards, which is what I want to turn to next. So these are the requirements that you need to meet in order to be eligible for a T visa. And I want to focus on the second requirement, which I call the physical presence requirement. So to be eligible for the T visa, a survivor must show that they're a victim of a severe form of trafficking and that they're physically present in the United States on account of the trafficking. So originally it was interpreted to mean that the trafficking occurred in the US and the victim had not left since being trafficked. However, in 2017, DHS expanded that definition of physical presence to cover some other circumstances, including instances where a victim's trafficking occurred outside of the US. At first blush, this makes it seem like migrants who are trafficked during their journey to the US can take advantage of the T visa. However, DHS limited these types of trafficking to situations where the victim was brought into the United States for purposes of participating in an investigation or a prosecution. So what does that mean? Well, DHS clarified that this physical presence standard means if a victim who's trafficked abroad and arrives to the United States without the invitation of law enforcement, they will not meet the physical presence requirement and will not be eligible for a T visa. So in the case of Ms. Gonzalez, she's able to overcome the physical presence element, but other victims are not so fortunate. So there aren't any hard statistics on how many asylum seekers entering the US are also victims of human trafficking. But anecdotally, I can say that during my time working in detention centers in New Mexico and in the El Paso area, I came across victims of trafficking regularly. So throughout my screenings, I would screen them. They definitely were victims of trafficking, but ineligible for T visas because it didn't meet the physical presence requirement. So this meant that they usually had to pursue a lengthy asylum claim after passing a CFI, and they would be held in detention or be deported after failing the CFI or the credible fear interview. So this, I would argue, is a serious and intentional gap in the T visa, which leaves many victims without protections or access to much needed services. Then on top of that, this is an issue because we're not allowing them any immigration remedy based on the trafficking. So then many asylum seekers are then forced to fight challenging asylum claims. So for all migrants, but particularly migrants who are also victims of trafficking, then they face an additional trauma and victimization of being in detention. So I want to end just really quickly talking about the re-trafficking that occurs while migrants are in immigrant detention. So, once detained, it's extremely common for individuals to be working for $1 a day throughout the duration of their detention, usually through voluntary work programs ran through various facilities. However, civil litigation over the past few years have shed light into the coercive tactics used by detention facilities to extract labor from detained individuals, amounting to human trafficking. So going back to Gonzalez v. CoreCivic, Ms. Gonzalez, as discussed, was detained for a little over a year as she was securing her T visa and fighting her removal case. During that time, she was subject to forced labor by the facility. And if she ever refused or tried to refuse, the facility would threaten her with solitary confinement, physical restraints, and deprivation of other basic needs like personal hygiene products. And she was paid $1 to $2 a day, but others in that facility experienced the same forced labor and threats and were not paid anything for their labor. So in 2018, Ms. Gonzalez brought forward a class action lawsuit against CoreCivic, which is the company that owned and operates the detention centers that she was at, for violating the TVPA, or the Trafficking Victim Protection Act, prohibition on forced labor. So her case is just a handful of suits being brought against private detention companies, such as CoreCivic and Geo Group, and those are the two largest correction or prison companies in the US. And then they routinely practice forced labor as part of their operating practices. So I know that was a lot to cover, but the two takeaways I hope that people get from this presentation is that, as currently structured, the T visa is largely unavailable to migrants who are trafficked on their journey to the US, leaving them to fight their immigration case many times in detention, where they run the risk of being re-trafficked. And even though detention centers are not supposed to be punitive, they basically function as a space where violations such as forced labor are practiced and even normalized. So we can talk a little bit more in the Q&A about recommendations. Thank you.
Thank you, Professor Rasa, for that thoughtful presentation on the challenges of survivors who are in detention, and also for perhaps leaving us with a bit of optimism in the sense that, that these civil cases against detention centers are actually making a tremendous difference, and that lawyers are bringing creative legal claims against detention centers and making progress. So with that, I want to invite everyone to include your questions in the Q&A function. And I'll go ahead and start off with a question that's been raised throughout, but, how do we reform the system? So I'm just going to ask a really broad, I would guess that each of you have suggestions in terms of both micro reforms and broader reforms that Stephanie referred to. So I'll open it up and invite you all to add.
I can start with that one. So I wrote this very brief piece about how do you do good anti-trafficking policy, and there's just 4 points to it. So the first is that you want to make sure that you're not using political capital, right, to pass anti-trafficking legislation that actually has no impact, right, for survivors. And we actually see that at the state and federal level because it is such a hot topic. So the first is that any anti-trafficking proposal you're consulting with survivors as well as service providers or those with experience on the ground. The second is that any proposal you put forward should deal with immigrants, US citizens, men, women, and children, sex and labor trafficking. We see a lot of legislation, advocacy, administratively that will focus on one subpopulation. Sometimes that's okay. So you can then ask the question, well, why does it just focus on one subpopulation? The third is, are you bringing resources with the new policy? Because what we know is that trafficking survivors are vulnerable from a huge range of vulnerable groups. So if we're just shifting resources to trafficking and we're taking it away from another vulnerable population, we're not really actually fixing our problems. We could be actually increasing trafficking, which goes to my fourth point, which is that we have to look very carefully at anti-trafficking policies and unintended consequences, because we have seen so much legislation passed that whether it hurts sex workers, it hurts migrant workers, it hurts others. And so these are very complex solutions that I think have to be nuanced for all the different ways that people are exploited. And that's why we have to take a progressive approach based on learning and good data.
Thank you for that, Professor Rasa. I'm just going to invite you if there's anything you would have to add.
Yeah. Oh, I'm sorry.
Oh, no, go ahead. No, go ahead, Professor Kim.
Oh, sorry about that. Thank you. Thank you, Professor Dahlstrom. And I absolutely agree with Professor Richard. I'm so glad we work together. So, so we don't have to worry about any political, ideological tension. So I think that, and this is really just expands on the issues that Prof. Richard raised, which have to do with resource allocation. I think that in paying attention to the necessary connection between actually good law, progressive law, and social movements, if we look at the historical backdrop, there are only two instances of progressive laws: Reconstruction, which was shortcutted after 10 years, and the Civil Rights Movement, which arguably was shortcutted after 10 years. And the most powerful social movement to date is arguably the Black Lives Matter movement. And I think that there are a lot of important talking points that have emerged from that movement about divestment from law enforcement and reallocation of resources. So I think we definitely, and I think that this is not just, being a sheep in the herd of the social movement. There's very good reason to scrutinize resources or policy measures that are used to concentrate more funding into law enforcement, because we've seen, and in the immigration context in particular, we've seen all the harms that result from that concentration of resources. Professor Rasa just gave the laundry list of human trafficking that occurs as a result of immigration enforcement and detention. And also Julie's and Heba's work, your work on the TVs, the Trump administration most draconian immigration enforcement machine, and has left, chilled a lot of survivors and then left a lot of survivors in perhaps worse circumstances. And what I mentioned earlier, just the collateral consequences of law enforcement agencies using trafficking as pretext for investigations, for their task force enforcement investigations, invariably put, arrest, detain, and remove individuals who should not at all be on the radar of enforcement.
Thank you, Professor Kim. And I want to open it up if anyone else has anything to add in terms of reform. And I know we only have 1 minute left, so we'll leave it at that. But
I mean, I can add just one last thing, which is to say that, as somebody who's studying this as a sociologist and who's new to sort of the legal process, something that really strikes me is that despite the fact that you do have this protection, the obstacles, the bureaucratic obstacles to actually securing the protection and the duration and the precarity that people endure as they're actually seeking out the protection that we're looking at is really jarring and violent, so there's like a bureaucratic violence underlying the whole thing in terms of just the actual logistics, despite the word of the law. And that's something that that I've been thinking about a lot and that I've mentioned to Julie before, and something that I would personally like to see reformed as a sort of stranger to this process.
thank you, Heba. And thank you also. One question I didn't have time to ask is just about the need for both interdisciplinary responses across areas of law. And that remains a challenge. And thank you all for doing this important work. So right now we're going to take a break until 3:10 and invite everyone back at 3:10 for a panel on intersectional responses in the hope that we can continue this important conversation. Thanks, everyone.
Started with our fourth and final panel of the day, intersectional approach to human trafficking policy and prevention efforts. My name is Sarah Sherman Stokes, and I'm the Associate Director of the Immigrants' Rights and Human Trafficking Program here at BU Law, where I have the immense good fortune to teach alongside the incomparable Julie Dahlstrom and to get to teach a number of the members of the Public Interest Law Journal. and of course, they are who have made today possible. So I'm so looking forward to hearing from our esteemed panelists today. I'm going to introduce each panelist, and then they'll have about 8 or 10 minutes to present, and then I'll introduce the next one, and we'll be sure to leave plenty of time at the end here for questions. All right, we're going to go ahead and get started. I'm going to start by introducing Sarah Byrne. She is Senior Counsel in Moore & Van Allen's Financial Regulatory Advice and Response Practice. She has years of expertise defending survivors of sex and labor trafficking and has received national recognition for her efforts in the fight against human trafficking. She is a co-founder of the Nationwide Survivor Law Collective, a national network of trauma-informed attorneys who provide legal assistance to survivors. Ms. Byrne works with the United Nations Finance Against Slavery and Trafficking, or FAST initiative, to expand victim access to financial services and to educate banks about the Survivor Inclusion Initiative. She brings a unique human rights perspective to businesses navigating the emerging legal, regulatory, and reputational risks associated with environmental, social, and governance issues, providing workforce training and advice on corporate policy development, anti-money laundering practices, supply chains, KYC diligence, and corporate disclosures. Thank you so much for joining us today. Go ahead.
Thank you so much, Sarah, for that very kind introduction. I trust someone will let me know if I have technical difficulty or if you can't hear or see me. Very good. So first, let me commend the Public Interest Law Journal editorial board on their extraordinary efforts in editing and publishing the written work that's associated with today's symposium, and for convening such a diverse population of professionals and stakeholders to highlight this important topic. I've really been so impressed with the content today, and I've learned a lot. So it's been a pleasure to be with you all day. Having worked with hundreds of survivors of sex trafficking and forced labor, I have learned that the foundation for victim-centered and trauma-informed legal representation of survivors is to allow for the client, the survivor, to define what justice means to them. As trained and practicing lawyers, we tend to define justice by a certain and measured objective, whether that's a conviction or an exoneration, a civil damages award, relief from a legal obligation, or imposition of a legal obligation. The goals we pursue on behalf of our clients generally are usually certain at the outset, and they're pretty consistent among those that we represent in similar circumstances. However, for those who have endured exploitation, abuse, and the deprivation of rights that corresponds with being trafficked, justice can only take the shape that is subjectively molded by the survivor, our client. This tenet comes into most focus for us here at the Moore & Van Allen Human Trafficking Pro Bono Project when we are seeking to advance the interests and protect the rights of victims in federal criminal human trafficking investigations and prosecutions. So for my short time with you today, I'm going to touch on those rights in that context that I see most at risk and for which survivors appear to be calling for the most protection. The foremost right at risk for sex trafficking survivors serving as victim witnesses in federal human trafficking cases is not explicitly addressed in the Crime Victims' Rights Act or the Justice for Victims of Trafficking Act or elsewhere. It is a right that has been discussed to great extent today, and it's the right against criminalization. For many reasons, mostly related to the coercive trafficker tactics and the impact of trauma, the behavior of human trafficking victims often causes them to present as offenders themselves. Psychologists and advocates and those of us that do this work now commonly refer to this phenomenon as victim-defendant duality or victim-offender intersectionality. This general concept presents, at least in our experience, in two forms. A victim may be perceived to have facilitated the trafficking by recruiting other victims, posting commercial sex advertisements or other work, or they may be criminally charged for such activity. The other form is a victim is being held accountable for criminal conduct that is ancillary to the trafficking, which can include drug offenses, theft, violent behaviors, despite being characterized as a victim in the overall trafficking scheme. Due to this unique intersection of victimization and criminality, most sex trafficking victims do not readily cooperate, at least in our experience, with law enforcement, for fear that they themselves will become a target of the same or a separate investigation. And for many victims, this fear is warranted. Because the risk of criminalization is very real and the fear among survivors palpable, our job as advocates is to ensure that victims continue to be characterized as just that, crime victims and survivors, and not perpetrators. Turning now to dignity. The right to be treated with dignity when serving as a victim witness includes a wide spectrum of protections. I submit that those include the right to not be detained as a material witness, which means being forced to testify against the trafficker, but also the right to be cast as only a victim and not a villain in criminal proceedings. A defense attorney representing an accused trafficker may elicit testimony and other evidence that casts a victim witness as someone who voluntarily engaged in commercial sex in order to demonstrate that the government has not proved force, fraud, or coercion. Victims' memories of events may change over time, or they may recant a prior statement, both common occurrences in human trafficking cases resulting from trauma, fear, loyalty, substance abuse, or perhaps because they're human. These circumstances, together with the victim-offender intersectionality, can lead a jury to disbelieve a victim witness in their testimony. Without proper explanation through expert testimony about the vulnerabilities that give rise to trafficking, the impact of trauma, trafficker tactics, and the complicated relationship between trafficker and victim witness testimony may only serve to hurt the government's case, and more importantly, the survivor's recovery. In addition to the very important rights to full and timely restitution and the right to presence of a victim's own attorney at all investigative and prosecutorial interviews, survivors have the right to be reasonably heard at any public proceeding in the district court involving sentencing. While the spirit of the Crime Victims' Rights Act is to give a voice to a victim in this important stage of the criminal process, it's important to understand that the right to not be heard is as worthy of protection. In fact, respecting a victim witness's decision to not be heard serves the rights to dignity and privacy and to be reasonably protected from the accused, which are similarly afforded under the Crime Victims' Rights Act. For reasons including fear of criminalization, fear of the trafficker or their associates, or in order to minimize the risk of re-traumatization, human trafficking survivors may decline to provide any form of victim impact statement. If that's their desire, that is their right that we ought to protect. And notably, this decision ought to have no impact on the mandatory restitution to be ordered to compensate those victims who so choose. Since guilty pleas account for well over 95% of criminal convictions, at least at the federal level, this means that this right in particular may be the one that is most commonly invoked or at risk in human trafficking cases involving victim witnesses. The Crime Victims' Rights Act explicitly includes a crime victim's right to be informed in a timely manner of any plea bargain. Recovery of restitution through plea agreements is particularly important because victims may feel deprived of the justice otherwise afforded through prosecution of the originally indicted charges, which would have resulted probably in a more significant sentence, and therefore a greater sense of safety and fairness for our clients. I'll last touch on today on a right that's a nascent one. It's a right that I call one of the future, and it's been given due attention already today. It's the right to access meaningful and restorative post-conviction relief. Despite increased understanding about coercion, victims, as we've heard so much today, are still unjustly penalized for their forced or coerced participation in crimes, including recruiting and training other victims and advertising commercial sex and other things. As a result, many victims end up being convicted of or pleading guilty to charges that can range from property and drug crimes to conspiracy, sex offenses, and others. For human trafficking survivors who are left with a criminal record and in some cases are required to register as sex offenders, this status can be a source of secondary trauma as the collateral consequences of a criminal conviction are swift and severe. Criminal records prevent trafficking survivors from being able to seek gainful employment, education, and secure housing, which all can contribute to the risk of re-victimization. Over the last decade or so, as you've already heard, almost every state has enacted some form of post-conviction records relief for survivors who were unjustly charged or convicted for crimes for which they were forced or coerced to commit. Filing petitions for expunctions and vacatur and records healing is a significant part of the work that lawyers like we do in our practice do every day. However, for survivors who were federally prosecuted for coerced participation in a trafficking scheme or other criminal activity, there remains no viable avenue for full relief, and we heard about that this morning. Any record, and certainly a federal record, can be a complete barrier to freedom. United States Senator Gillibrand from New York has introduced the Trafficking Survivors Relief Act a number of times in the United States Senate, and I hope we'll do so again. The Trafficking Survivors Relief Act would include relief from federal arrest, charge, and conviction records for conduct that was the result of trafficking. But importantly, federal vacatur legislation ought to include language for an affirmative defense that could be asserted at the time of prosecution, wholly eliminating the need for post-conviction relief. So that's a really important part of any forthcoming legislation. Unless Congress acts to pass such an important bill, human trafficking survivors, who all too often carry the weight of federal criminal convictions for conduct that was forced or coerced, have no path to remedy or opportunity to restore their rights to not be criminalized for their exploitation. So I hope I leave you with a message of hope that federal vacatur may become a reality for survivors, and hope that all other survivor rights, those that I touched on today and otherwise, will not only experience expansion, but increased protection by advocates who listen carefully to the individual goals and interests of each survivor that we dutifully serve. Thanks for your time, and I'll look forward to questions at the end of the other panelists' remarks.
Thank you so much, Sarah, for that powerful case for legislation that can address some of these concerns. We're going to turn next to Jose Alfaro, a human trafficking survivor, public speaker, author, advocate, and activist. He has worked with several anti-human trafficking organizations across the globe to spread awareness on trafficking, specifically within the LGBTQ+ community. He is currently working on a memoir depicting his own personal experiences with trafficking. He has been featured in several publications and has worked with various law enforcement offices, including DHS and the DOJ. Thank you so much for being here, Jose.
Thank you so much for having me. Oh boy, like hearing your bio said out loud, it kind of feels a little, a little awkward, but anyways, I am so honored to be here today and privileged, to be honest with you. I've only been doing this work for a few years now, but I have to say I've been living with my traumas for my entire life, you know, and with those traumas comes shame and guilt. My story and most survivors' stories are much more than just human trafficking. I find that human trafficking for most is a result of systemic and institutional failures. What I hope to share with you today, though, is the importance of restitution and how a few changes can better support survivors through this process. So I want to ask for forgiveness ahead of time because I am so excited to share this with you, because this is the first time that I've actually been able to share this information. It has been a very long and gruesome process for me. And so I hope that it will be helpful to many of you. So in 2018, I testified in a trial against my trafficker, and Jason Gandy was sentenced to 30 years in prison with no chance of parole. But what I didn't realize when testifying was that I would be catapulted right back into how I felt when I was 16 years old and when it happened. And so when I heard about the restitution, I really had hope that maybe this was going to be something that was going to help me move forward and move on from all of what I had experienced. But instead, I was given the restitution form with 0 instructions. And not only that, even with instructions, because later on I eventually had to beg for them, but it felt literally impossible and extremely overwhelming. And so there were a few questions that I asked myself, like, how was I going to come up with a dollar amount that was going to make me, and I put in quotations, whole again? And not only that, how was I going to provide receipts and proof that I needed this restitution? And I have to mention, you know, testifying in a trial in front of a judge, you would think that that would be enough to prove the trauma that you've already gone through. So I want to talk about my first attempt at trying to fill out this restitution form. And the number that I came up with was $5,000. And I have to mention that because $5,000 would last me, what, a month maybe? That's not including rent and a few other necessities that I would need. But after finally, reaching out and asking for more instructions because I was completely lost, I formulated a dollar amount 5 times the original amount. So here is what I came up with, and forgive me because I've never shared a screen before, but I am going to attempt this. Is that visible to everyone? Perfect. So here I put in my transportation, the Uber, the psychiatrist visits, therapist visits, medication, worked, missed for the therapist and the psychiatrist. And this totaled out to about $25,344. I also want to mention that down below here, this is how I calculated my hourly wage. Because I am a hairstylist, I am not paid hourly. I am paid based on the number of clients that I bring in. So this was another hurdle for me in trying to calculate a number. So in November of 2018, I submitted the forms and assumed that it would be reviewed and the amount would be seen as an amount that wasn't nearly enough to make me whole again. And I have to use that because that is what I was told what restitution would do for me. So I'm gonna show you something that a clinician and I were coming up with, what it really takes for survivors and what they go through. And this is with the help of Landon Dickinson from Bob's House of Hope. He's a clinician there and works with many survivors. Here you can see human trafficking victims rarely come forward to seek help, whether they are unable to do so or their vulnerabilities are being exploited to prevent them from seeking assistance. They rarely know their rights and how to get help, or they are afraid to reach out for fear of being hurt, arrested, or deported. Treatment must address the traumas in order to prevent crime and break the cycle of exploitation. We need trauma-informed accountability in our criminal justice system. And I know that some of these might seem as though, like, what does this have to do with restitution? But it actually has a lot to do with restitution, and I will explain later on. Service providers, law enforcement, and other community members who interact with victims may be unfamiliar with the indicators of human trafficking. Sometimes they perceive victims primarily as teen runaways, juvenile delinquents, users of illegal substances, or prostitutes. This can generate inappropriate responses and ignores the very vulnerabilities for which traffickers targeted them. And I'm going to skip the next one and go to the last one just for time. Victims often require a wide range of short and long-term assistance. And I think that this is the most important one of all, ranging from immediate shelter, nourishment, and medical care to lawful immigration status, housing, education, and employment opportunities. Receiving adequate and appropriate assistance as soon as possible is the intervention victims need to stabilize, avoid falling victim again, and work towards recovery. And I really want to mention that that last one is very, very important because this is what it takes to really become whole again. And so looking at that number of $25,000, I can't say that that's going to be enough to help me through and move on with my life. And I'm going to leave this slide up just so people can kind of take a look at what I formulated there. So nearly an entire year went by, and I am told that there was a mistake that was made, but it would be fixed. So I waited, and by the end of 2019, I was told that I would receive a check before the holidays. I waited, but it never came. And I want to mention the holidays are a moment where we spend a lot of money on gifts and we want to, show people love and how much we care about them. Waiting for this check and being told that I would receive this check was so disappointing. Not only that, I went out and purchased gifts that I probably could not afford on my own. And I did it thinking that this money was going to come for me. So in 2020, we were all eventually in the middle of a global pandemic. And I had no job. Mentally, I was unstable. And I feel like that's how we all kind of were, not knowing what to expect. But I had still I had heard nothing about restitution. And so I was kind of in this panic mode. And so I had no choice but to begin my own investigating. And what I wanted to know was, how much did the government actually seize in assets from Jason Gandy? And so as I began my research, I eventually found out that the property was auctioned off a month prior to my investigating for over $250,000. So now I'm aware that the US government is sitting on $250,000, and I'm questioning, where is the restitution that I was promised over a year ago? So I was excited because I also thought that this was an amount that I would receive in whole, but I later was informed that even though I had a civil judgment, so I participated in a civil suit against my trafficker, and I had a verdict of 1.43 million. But even with that judgment, I learned that because these are two separate cases, this money would not just be given to me. And so, you know, surprise, surprise, is basically what I told myself. But once I realized that I would not be receiving this full amount, but only just the 25K that I submitted, I had one question. And that one question was, what happens to the other $225,000? And I have to mention that when I asked this question, I was met with hesitance. But I eventually was told that the money would go into a fund, and I had to dig a little deeper. So I asked the next question, who does this fund? And I was then told law enforcement. So I'm no dummy, but I realized that this was going to the government. And I was angry, I was shocked. And I began to call attorneys to figure out what was happening and how this was even legal and possible. But I feared that there was nothing that could be done. And so I actually came in contact with an attorney. Her name is Martina Vandenberg at the Human Trafficking Legal Center. And she helped me to try and get that money much quicker. And by the end of 2020, I was again expecting a check over the holidays. But I want to mention that I was then told that the amount that I had submitted was already approved by a judge, so there was nothing that we could do to go back and try to claim more of that money. And so then I was given a good news call, and I was told that we would begin the remission process. And what the remission process was supposed to be was a second chance at claiming more of the restitution. And of course, I questioned, how are we here now after almost 2 years? And now suddenly you're telling me that I can claim more money. If anything, I was not excited because I had waited so long as it was. And the first question I asked was, how long is this going to take? But I also wondered why they couldn't just send me the money for the restitution, and then we could begin the second process of remission. And this is where Martina really stepped in and helped me through this process. I have to say that it was really tough. We were met with a lot of excuses. We were told even at some point that they didn't even know where the money was located. But eventually, the more we pushed, they ended up wiring that money to me directly and immediately. So I immediately realized that this process, because it was so hard for me, I couldn't imagine what the other survivors in this case were going through. Even though I was told that these other survivors did not want to participate in the restitution process, I contacted them anyways. And I wanted to inform them that we were going through a second process called the remission process. And I'm sad to say that I was told that they had no clue about the restitution to begin with. And the second part was they also were not contacted about the remission process either. And so as much as I could have been selfish and just taken all of the money, I really, really felt for them. And so I took it upon myself to connect them with the Human Trafficking Legal Center to get them connected with pro bono attorneys to help them through this process. So speaking with the other survivors, I also want to mention a lot of things that we discussed. We discussed what participating in the trial felt like. And a lot of us were dealing with these suicidal ideations. We felt like there was no point in us to live any longer because we were, again, put right back into that place that we were when we were teenagers. We were all dealing with mental health issues. I assume that some of them may have even possibly gone out and participated in sex work because they had no money. And I even took it upon myself to send one of the survivors money myself because he told me he didn't know how he was going to eat the following week. And so I have to say, like, this just goes to show the importance of what restitution is and how quickly this money needs to get to the survivors. So I want to say that my goal is not to call people out, but to point out how harmful, but also important this process is. I feel that this process needs to be made much easier for survivors. And every survivor should be immediately connected with a pro bono lawyer to help them through this process. Thank you so much for having me. I hope that I'm okay on time. Great. I want to mention that, again, this is my first time being able to share this, so I'm sure I just left a ton of information for so many people, but I was so excited to actually finally be able to share this. I think that where we're left within this process is 3 out of the 4 survivors have finally been paid their restitution. I think we're waiting for 1 more, but I can't tell you, I mean, 2.5 years to finally receive the money that was supposed to be given very early on. It was really disappointing. And so I hope that this is helpful. I hope that you realize the importance anytime you're working with a client who has this lived experience and has gone through this type of trauma, because ultimately it's not a win until they're able to move forward with their own lives. So thank you so much for having me. And I'm excited to hear any questions that will be given at the end.
Thank you so much, Jose, for your just incredible courage and for being here today. I'm so glad that we get to feature your voice. And I'm so sorry for what you've been through, but I'm grateful for your resilience and courage in sharing. I look forward to hearing more from you in the Q&A. And we're going to turn now to Lydia Ferreira. Lydia is a worker rights organizer at the Brazilian Women's Group. She helps organize the Massachusetts Coalition of Domestic Workers Council and represents the group in the Immigrant Worker Center Collaborative and the Fair Wage Campaign. Ms. Ferreira is currently writing a book on domestic violence. Thank you so much, Lydia.
Hi, good afternoon. Thank you so much, Sarah. Thank you all for this great opportunity. It's not the first time that the Brazilian Women's Group has been invited to this kind of plenaries, I would like to share some of my experiences working with labor trafficking survivors. Just correcting you, Sarah, I know you mentioned that I was writing a book about domestic violence. I launched the book in 2018, and it was based on the experience that I have been with workers here, our community sharing their own experiences. Well, I would like to share my screen if you allow me. Thank you.
You should have screen sharing permissions.
Yeah, I do. I don't know if you'll be able to. It's a new computer, and I don't know if I set up the system, but it's okay if I can. It's okay. It's not a problem. Well, the Brazilian Women's Group is a nonprofit organization that's founded in 1995. And was created by a group of women and interested with the interest discussing about immigration needs and women's rights. And as an organization, we have been working with our community, trying to organize the community to bring empowerment to the women, and also providing civic engagement and many other projects. With civic engagement, we provide system classes, ESLs, and voter registration. And we have an immigration rights free clinic, legal assistance, know your rights sessions, and that is very important to our community. Also, as a project, we have a workers' rights project, Vida Verde Women's Cooperative, the Brazilian Independence Day Festival, a radio show called, its name Estação Mulher, and the project involving domestic workers. In our community in 2010, the census come with the 350,000 Brazilian living in Massachusetts. And for those, we believe 75% of the majority are house cleaners. That means the majority of women of the Brazilian women in Massachusetts are house cleaners. And for the men, they work as a construction and restaurant workers. We know that is very important for us to have a stronger and system related to labor trafficking, especially because the major problem related to workplace violation is fear of retaliation based on immigration status. It's a big issue for the community to fear that something could happen with them if they decided to file a claim against their employers. We know many workers who are very concerned about going to work and not be able to fight for their rights, especially because they know they are undocumented. And it is something really sad, especially for those who face any kind of workplace violation, like such wage theft, sexual harassment, workplace accident at workplace, and many other issues. And then they can, or they are very concerned about it, to file a claim or even to ask for help. And we have been seeing cases of workers who have been struggling to talk with, even with us as an organization, and starting the process to file a labor trafficking case. And the other issue is the lack of English proficiency. And it's very difficult to understand the system. It's very difficult to, especially if we can speak the language. And the financial and the mental impact related to the workplace exploitation is a huge issue in our community. And we really fight and help and support our workers, our membership, and our community to know how to fight against those issues. We know that it's a very important to have not only organization and like the Brazilian Women's Group and many other organizations that we have here, but also to understand how can we improve our work to restrain the relationship between workers and organization and the legal service. And we are so happy and glad to have Julie Drumstone with us, helping us through not only through the process, but also to educating workers. I see as a solution that could help the system and go beyond the criminal legal system is create a multilingual resources. We need to have more resources in our own language. As an immigrant, and I know how important it is to know that is a material that I can read on my own language and share with workers, and then they can comprehend and understand how to work with the system, and also how to get to be protected and get help. Also, we need to have more community engagement. It's not only the legal part of your work, but also to engage with the community. It's very important to the lawyers, the attorney, to know better how to connect with workers, how to understand the issues related to immigration, and also to understand the culture around the immigration. And the other thing is to humanizing the justice system. I know the legal part is very important, but when we understand how difficult it is for those who are working for so long, trying to provide food for their family, or how to get their wages, or also to face the employer after many violation, exploitation, and to have a lawyer who can understand how difficult it is to share their own experiences. And if we can bring all those experiences, like Jose mentioned about his own trauma, is very difficult to cope and to deal with. But I believe when we humanize the issues and bring those issues as the way that we can connect with workers and try to speak the same language, not the language of Portuguese or English, but the human language that we can share, and try to be open to them to tell their stories. I know that the part is very difficult to deal with, waiting for long months and sometimes many years to bring the final results, to get the solution for their own problems, and to face that is hope for the situation that they are facing, is a huge impact for our community. I see also how the help of the attorneys has changed not only the lives of the workers, but also their families around, when they know that there's someone who they can trust because they are being supported by them. I'm thank you so much. I'm here and open to any question and comments. Thank you.
Thank you so much. We're going to turn now to our fourth and final panelist before we break for questions. Dr. Anita Ravi is a board-certified family medicine physician, public health scientist, and nationally recognized expert in the areas of gender-based violence and trauma-informed care. Dr. Ravi is the CEO and co-founder of Purple Health Foundation, PHF, a nonprofit organization that invests in the physical, mental, and financial health of women and girls who have experienced gender-based violence. She's also the owner of Purple Family Health, a PHF-affiliated medical practice that provides comprehensive healthcare and employment opportunities for survivors. Dr. Ravi serves on several national committees to advance health equity, including the National Human Trafficking Training and Technical Assistance's Advancing Equity and Inclusion Technical Working Group. Thank you so much for being here today, Dr. Ravi.
Thank you so much for this opportunity. And I'm going to share my screen. Great. All right. So I've been looking forward to this ever since I got the invitation a few months ago, because honestly, lawyers are the reason that this clinic exists, for a variety of reasons, the work that I do, and it's because of creative, kind lawyers who go above and beyond. And frankly, like I've just learned so much, and it's an honor to be able to share where we are in this process and how we get to work with phenomenal people in this space. So 3 things that I wanted to be able to touch base on is kind of a reflection on how we approach healthcare when we work with survivors of trafficking. And I think I want to walk you kind of through what we're doing at Purple, the Purple journey. And the three kind of concepts that come to mind are these things of trust, this concept of winning and what winning looks like, and financial health. So I'm going to walk through that. So back in 2015, I live in New York City, and that's where Purple Health Foundation is based. And I used to volunteer on Rikers Island in the women's jail, and I used to do health education groups there. And it's there that Legal Aid Society, their exploitation intervention project, used to come, and they would do Know Your Rights. They would look for people who had histories of trafficking and to help them with vacature. So that was the first time as a physician I learned that I know how stupid this sounds, but that trafficking survivors get incarcerated for things that happened while they were being trafficked. Like for the average Joe who's just walking around, like that's nuts. And so I had no idea that that was happening. And the more that I was learning, both from their workshops and from the people that I was working with inside when we were doing health education groups, it made me realize there was a big gap in what healthcare could be doing and should be doing. A real big focus, I think, in general in healthcare in this area is to focus on acute needs. So we look at identification of survivors, or we look at emergency rooms, or gonorrhea, chlamydia, STIs, things like that. But as a family physician, I take care of the whole family, and I take care of the children of survivors, and I take care of people throughout their life course. So not just here and there if there's an acute issue, but like diabetes, cancer, like lifelong things. And so it made me think more about what I could do with the resources that I had. So I had amazing community-based organizations who took the time to educate me in understanding more about the space in healthcare. And so I did 2 projects where I interviewed survivors of trafficking who were incarcerated on Rikers, asking them about their healthcare experiences while they were being trafficked, and also asking their advice for what would make them feel more comfortable connecting with healthcare. And this concept of trust is so important for 2 reasons. One is, here's a quote from a survivor, and she's like, the health field is just scary because you got all these 100,000 doctors and everybody's got their white coat. So now it's like, here's another one. It's just like another officer. Here's another one. And that is so important because you can build all sorts of programs, but if people don't trust the sector that you're in or what your intentions are, then you may never connect with the people that you're hoping to serve. And so that was really important. And that's why I bring up the lawyers that I work with, because when what I learned from community-based organizations is they were like, oh, great, you're doing research, but people actually need care, people who are undocumented or people whose barriers are not just insurance status, but shame and guilt and all sorts of other things, and medical trauma from past bad experiences in healthcare. And so I did an internship with the Legal Aid Society in the summer, and I started this clinic called the Purple Clinic. It was inside of a community. It was inside of a community health center in New York City, and I would run it on Sundays. And when I first opened it, no patients came, and Legal Aid, that team was they worked so hard to find people because they're like, people need healthcare, but it takes a lot of trust to walk in through the door and actually know what to expect. But the thing is, the people that I worked with, they trusted their lawyers so much, and to the point where people would be like, if I ever win the lottery, she's going to get half of it because she's helped me so much in my case. And I'm not always sure that the legal teams realize what a big impact that they're having when they go above and beyond. Like someone bought coffee for their client and she'll never forget that. And she tells me about it in clinic. So what I started doing is I started getting referrals. And this is the kind of referral that comes in from a lawyer. Like the lawyers that I get to work with are looking above and beyond kind of the legal case and picking up on other health related issues that are looking at people's health, livelihood long term. So this is just an example. It's not an actual person, but client was sex and labor trafficked, 45 years old, hasn't seen a doctor in a while, arrested many times, been through a lot of trauma, has not had medical care or mental health care in a long time, in a shelter. We're working to get her old convictions vacated. She's living in a shelter. She was trafficked from a young age and has really had a difficult life and trying to get stability. So that helps me understand kind of my role in the team and what I can do to contribute to her health and her wellness. So that's how things started. And I was like, okay, great. I know what I'm doing. I just have to do the healthcare piece. I do drawings. I know before Lydia was kind of talking about language, and many of my patients, like English was not their primary language and English is my only language. And so sometimes we would draw in clinic or communicate, and I would also use drawing as a tool for advocacy because I was learning so much that I didn't formally learn in medical school. And there were things that were keeping me up at night that I couldn't quite connect the dots on. So patients would come in and I would see someone again who'd had delayed care, and maybe I would do a breast exam and say, yeah, like, you know what, there is a mass. And then I'd print out this ultrasound and I'm like, okay, all you have to do is go and get this ultrasound as the next step, and then we can figure out the results and go from there. But I have no idea whether they can afford it or not. And sometimes I wonder if our patients are thinking the same thing. So when we looked at our purple data over 4 years, I ran that clinic from 2015 to 2019 before pivoting to what we're doing now. And we found the average income among anyone who was even making money was $281 a month. And the cost of a mammogram or an ultrasound in New York City is around, anywhere between $120 and $300. So among all the other expenses, like most people, sometimes they don't come back after you diagnose something and you hope that things are okay. But sometimes I wonder if my patients are laying there hoping that it's okay too. That was hard. The other thing too is there's so many other, when you think about financial health, sometimes like we do the service and we bill people, but like there are so many other competing interests, right? So people couldn't always pay for their cell phone bill. They couldn't always pay for food or things like that. So even if I wanted to call back with results, like you realize there's so many other competing interests that you have to be thoughtful of if you really want to invest in someone's care, their health care. And then finally, like the big thing that Jose was talking about and others have talked about as well is the mental health piece. Like it was cool when I got referrals for people who were like, she's going to go back to work. Can you just help do a pre-employment physical? And I would do that, but it was so hard for people, not even just to get a job, but to keep a job because of the trauma that comes with it. And when we looked at our PTSD results, it was similar to like the results we got were similar to people who have served in war at the VA and like we're accessing mental health services through the VA. And we don't have things in place in the community to be able to support survivors through their long journey to really work through their trauma and to be able to thrive beyond it. And as someone was saying before, like 1 in 3 of my patients at the time when I saw them, they had marked the box that said they felt they were better off dead. And like, again, if you're trying to hold a job, if you're trying to take care of your children and not lose custody of them among all this other stuff, like it's so important to understand because it impacts people's health. So with my last 2 minutes, I want to talk about winning. So it's funny, Jose mentioned Martina Vanderberg. So I was on a panel with her I think in 2019, it was when I was in the throes of like, is what I'm doing actually helpful or could we be doing this better? And somebody asked a question that said like, what's the best part of your job? Like, what does winning look like? And I just remember she was just like, it's so great. Like when you win a case, like, you've helped someone, that is such a great feeling. And I was thinking about this again, because I was like, well, what does winning look like in healthcare? Like, I know for me, I'll do a pap smear, but then they get a bill that they can't pay and then that's over. Like there's these moments, but I don't know how I'm making a difference in someone's long-term health or safety. So I took a step back and I was like, we can do better, healthcare can do better. So I joined with other people who felt similarly, including one of my former patients. And we built a nonprofit called Purple Health Foundation. We're investing holistically in people's health. And these are just some of the features. It's integrated physical, mental, and healthcare. We ask, like, do you have a bank account? Do you know your credit score? Like, how can we help with that? It's intergenerational. We have employment opportunities, like Keisha is our first care navigator survivor leader in our practice. And we collaborate so closely with other orgs. And this is just pictures from our opening day. And it was really great. Like community-based organizations came and they wrote down what their wish list was, like things that we could do from a healthcare perspective, whether it's helping people with testifying, with housing applications, other things that should be normal in healthcare. So we just opened in November our services, and those are the main things. So this is my review of like the role of kind of multidisciplinary collaboration and this themes of trust, winning, and financial health. This is my contact info.
Thank you so much, Anita Ravi. This is Julie Dahlstrom. I know that Sarah Sherman-Stokes, thank you for your moderation, had a commitment. And this is also a ploy that I had to get involved with this amazing panel. I have to also say that I'm such a big fan of Anita Ravi's work and drawings, which I've seen in other presentations. So I'm gonna go ahead and invite Q&A. So feel free to include your questions here. And I'll start with a question back to the panelists about, a number of you brought up the issue of survivor leadership, engagement, and how essential that is. And so I'm curious, perhaps Jose, who I'm really delighted to see today, you could start us off with, what recommendations do you have around ensuring that those with lived experience kind of lead the way, and then invite others to add to that?
Absolutely. The importance of hearing survivor leaders speak is critical, to be honest with you. It's like, how do we improve and how do we get better if we're not actually hearing the people that are experiencing it? And that's why I'm always so thankful when I'm invited. So thank you, Julie, for inviting me, because, to have this opportunity and have a large platform where I can share, I hope that people can realize the importance of hearing my experience so that it doesn't happen again, or even we can make the changes so that it doesn't happen for others. But not only that, I want to mention one thing, because I know that there's several reasons, but one that was really important for me is hearing from different types of survivors with lived experience, right? It took me a very long time to identify as a human trafficking survivor, because I didn't know that it could happen to males. And so finally being able to understand that, I think that it's highly important that we highlight many different types of stories so that people can identify through those stories. So I think that that's probably the most important for me. But I'm excited to hear everyone else's response.
Thanks, Jose. And if anyone wants to add, feel free.
I'll just mention, in the beginning part of my remarks, when I talked about for legal matters that we help survivors for, we have to ensure that they define what justice looks like to them. At our program, we've applied that concept overall to the services that we provide. And I'm so glad that Dr. Ravi had mentioned financial help, because we now have expanded into credit repair for survivors, which I know isn't really legal in nature, but we partner with some volunteer programs with financial services companies, and those financial services professionals are paired with a survivor to help do the credit repair and talk about financial health and all of that. So that concept came out of, we must listen to the survivors and what's a priority for them. They may say, I want to hold off on the expunction. I'm really worried about my credit score. So we need to hear that.
Thanks for that. And it looks like we have a question for Dr. Ravi here in the Q&A. So I'll direct this to you, Dr. Ravi. You mentioned receiving referrals from survivors' lawyers. I'm wondering if you can also get referrals from other providers in the healthcare system. I feel many times providers encounter patients in difficult situations, but don't know of all the amazing places that could help them, like the Purple Clinic.
I appreciate that question, because so when we talked about winning before, people are like, oh, so is the goal to have hundreds of Purple Clinics? And the goal is actually to have 0. Because ideally what would happen is, like, if you don't need to, ideally, people could walk in through any door in a healthcare system and get thoughtful care that they need. And that's thoughtful both for like trauma-informed care and financially sensitive care. And so we do a lot for trainings of providers so that and healthcare systems, because there's always that one champion inside who's like going to change the system, and you have to find them and then help empower them so that they can change from within. And for us, usually if people are already connected to healthcare, then there's nothing different we're doing, so we would never want to rupture that relationship. It's more supporting the provider who's already there. For us, we were really focusing on people who are like, I have not seen a doctor in 20 years. I am scared. I don't trust anyone, but I trust, maybe someone who'd recommend this person. So that typically we mostly work with people who've never, most of our referrals are from the community, because people aren't connected with care at all.
Thanks so much, Dr. Ravi. We have another question for Lydia. It's wonderful to see you, Lydia. Thank you for joining us. And I just wanted to ask you, workers' centers and workers' groups play such an important role, and also often do not frame their work as one of trafficking, but frame it much more broadly situated as workers' rights. And I'm just curious if if you have thoughts about the value of that frame, as well as just the value of community grassroots work more generally, and how it connects to trafficking.
Yeah, thank you so much for your question, especially because the labor trafficking is very, very small piece of the work that we have been doing. And also, the Brazilians, they can understand what means to be trafficked. They can understand what it is, labor trafficking, especially because in Brazil, we have a different approach of labor trafficking and human trafficking. But sometimes what we need to understand that is we have a huge community and we have a small organization doing so many things. And of course, it's not only the legal part that we try to refer cases to, but also the emotional support that we try our best to support and to give. That's why it's very important for you guys to be connected with us and to learn more from us and to know about their storytelling is very important.
Thank you, Lydia. And this is actually a nice segue into perhaps our final question. So we have an audience of lawyers and law students. Some of you are working with lawyers, and I think Dr. Ravi mentioned sort of the creative, engaged, kind lawyers. So I'm curious just to ask you, you all, what your advice is to law students or lawyers who are engaged in this work. Do you have any advice for kind of working across these silos or different areas?
Well, I'll just say, thank you, Professor Dahlstrom. My relationship with you has also showed me that there's such interest among young lawyers and law students to get involved in this space, which this wasn't even on my radar when I was in school and my early years of being a lawyer. So I'm thrilled that there's this army of enthusiastic young lawyers and that there's so many different avenues that they can pursue, whether it's working in the nonprofit space, in government, at law firms. Earlier today, I was on the phone with an assistant U.S. attorney who's doing excellent work in this space. I was also on the phone with a nonprofit attorney in California that provides free legal services. I'm housed in a private law firm that, our mission is to provide free legal representation for any legal need for a survivor that comes our way. So I guess I'm just excited about the enthusiasm and just know there's so many different paths that you can pursue to support survivors and hopefully advance the cause.
Thanks for that, Sarah. Any other thoughts?
Yeah, Julie, I don't have my long list of 10 tips that you've heard before, but one of those tips that I constantly highlight is to remember that a lot of survivors are not attorneys. And so the language can be very foreign to a lot of survivors. And so really taking a step back and taking your time to explain anything and everything is so important. Not only that, I found myself many times sitting at home having so many questions and wondering what was going on. And I sat on Google for quite some time as well. And so just checking in with your client and seeing if they do have any questions, or even just to let them know that you don't have any information for them, but you're just checking in with them, really goes a long way.
Thanks for that, Jose, just the value of information and communication. I'll open it up for anyone else who wants to add. And if not, we'll leave it there. I want to thank all of the amazing panelists for joining us today. And in some ways, this is a nice note to end on in the sense of how we can move across our silos and engage together in building more creative and effective responses. So with that, I'm going to transition to Madison Bush, who's going to offer some final remarks, and thank you all for being a part of this panel.
Thank you. Good afternoon, everyone. My name is Madison Bush, and I have been honored to serve as the Symposium editor for BU Law's Public Interest Law Journal this past year. It is a great pleasure for me to see this event come to fruition and to say a few words at the end of what has been a fantastic, informative, and thought-provoking day. Human trafficking is a critical problem, affecting millions of people on an annual basis. Human trafficking plagues not only our communities, but communities across the world. Today's panelists and speakers emphasize the need for collaboration to address and ultimately to end this global problem. Collaboration among state and federal officials, collaboration among public and private services, and collaboration among lawyers and law enforcement and sociologists and doctors. After hearing from each of our distinguished speakers, I feel confident that we are on the right track to ending this exploitation and uplifting its survivors. Before I take a moment to thank everyone who made this event a success, I want to remind anyone who might have missed a panel or who wants to share this event with family, friends, and colleagues that a recording will be made available online following this presentation. So many people have contributed in so many ways to transform this event from a humble idea into this incredible collaboration across intersecting fields, which we witnessed today. First, I would like to express my appreciation to the panelists for their valuable contributions to our symposium. It is only because of your generosity to spare your time for us that we were able to host this program today. As evidenced by each of your presentations, there is so much to learn from your knowledge and your experience. We sincerely appreciate not only your critical analyses into the present challenges, but also your thoughtful solutions and recommendations for advancement. Thank you for the work you do. I also want to thank our amazing speakers, U.S. Attorney Rachael Rollins and Attorney General Maura Healey. Your presence and wise words helped magnify our cause in the best possible way, and we look forward to your continued collaboration with BU Law. Thank you again to our wonderful sponsors who are doing great work in these fields. BU's Party Initiative on Forced Migration and Human Trafficking, BU Spark, the Human Trafficking Institute, the Massachusetts Attorney General's Office, and WilmerHale. A special thank you to the PILJ team, in particular, PILJ's Editor-in-Chief, Kennedy Barber-Fraser, and PILJ's faculty advisor, BU Law Professor, Julie Dahlstrom. These two women not only created this opportunity for our journal and for the BU Law community and communities elsewhere, but contributed significant time and effort and offered endless support to bring this event to life. Without your constant support and active guidance over the course of this year's planning, it simply would not have been possible for us to turn our dream event into a reality. On behalf of PILJ, I want to extend my sincere gratitude to Dr. Angela Onwuachi-Willig, Elizabeth Clancy, Kim Hobart, BU Law's Academic Media Services team, and everyone at BU Law who worked tirelessly to make this event a success. And last, but certainly not least, my deepest gratitude goes to all who attended the symposium and helped to make it such a successful event. We hope that you are leaving today's symposium feeling energized and hopeful that through continued collaboration and an intersectional approach to human trafficking policy and prevention efforts, we can put an end to this global problem. Thank you again.